No, we are not including any matters in appellate or original side.
My lord, most important, my lord, most urgent upgradation, my
No,
lord.
Mr. Adhikari.
My lord, with folded hand, I am saying, my lord, I will be.
The original side
Remove my-
mentioning time now.
My lord, yes, at the time of 2 p.m., my lord, at 2 p.m. we will come, my lord.
We may refuse.
May refuse,
Call on
but
the
my lord,
list.
will be refused.
No,
from
only
the-
application.
No,
Application
call
for
on the list, please. Call on the list.
application for restoration, my lord.
Original site mentioning, well,
Yes.
original site mentioning.
Original side mentioning what?
Well, item number 11, well, I'm mentioning upon notice. Well, there is.
Oh! Can't you hear what you are saying? This is not the way to behave in a court of law. Please. Please go behind. No. Refused. Yes.
Well, item number 11 of your lordship's list. Well, there is an urgency in the matter. Well, this is a restoration application of an appeal from a decree. Well, the decree holder is proceeding with execution, and the executing court on the last occasion indicated that unless there is an order of stay on the execution or on the decree, the executing court will proceed on the 7th of January. Well, I understand that only Wednesdays your lordship takes the original sides up, but well, there is only one available day, which is on 7th of January. So if your lordship could kindly give it some precedence on
So
this.
mention after the vacation. Mention after the vacation.
But
No upgradation right now. No.
not before the vacation. If your lordship could take it
Mention
up
after
on
the
7th.
vacation, we'll consider that.
But,
Oh, acha, we don't have any days.
Yes, that is why I'm mentioning that.
Well, 7th it will appear as at the top of the specially assigned matter.
I'm so grateful.
Yes.
My lord, I beg unconditional.
Call on the list, please. Yes.
Malod, I appear on behalf of the respondent. Malod, I am seeking for a short password. Malod, I'm being led by Mr. Chaudhary. He'll be addressing your lordship. Malod, short password.
A family settlement deed was required to be registered and executed.
Yes.
Parties were at variance with regard to the stamp duty payable there.
Right.
Ultimately, my lord, now the draft deed and the query which has come from the special officer appointed by this court, my lord, we have agreed to this.
We have
So-
recorded that also.
Yes, my
Yes.
lord.
Only thing
My lord,
That
there
has
are
to be now
No,
done.
not
there are certain aspects. My lord, there are three aspects. My lord, will kindly grant a short password. My lord, Mr. Chaudhary.
aspect, my lord? They were
My lord, there-
We have recorded that you are ad idem on the registration of the deed of family arrangement.
yes, and
And you
last
assured
day,
that you
my lord,
take steps.
last day could not be done because there was an order of status quo that has now been clarified, my lord. That has been
Yes,
clarified.
yes. What
by the
other
court.
aspects?
my lord, there are three aspects to the matter.
What are the aspects?
My lord, I need a direction on the special officer also to execute documents on behalf of the deceased parents of Swaika and a direction on
On behalf of deceased persons, how can it be done?
Deceased parent.
Sir,
Can someone execute someone in the name
My
of...
lord, that is the clarification Mr. Chaudhary would
If
be.
the deceased person could not do it today, how can someone else do it
My lord,
on
that is
their
the
behalf?
my lord, that is the
What
clarification.
peculiar proposition you are making?
Deceased person, how
If
can-
I am dead today, somebody on my behalf can do it. If I can't do it,
My lord, that is the clarification he'll
no,
be
that
placing it.
clarification is refused. What else?
My lord, then there's a property in Moore Avenue, my lord. There's a company Moore Avenue Private Limited.
See, if you are not ad idem, then you could have told it on the last occasion. We have been adjourning the matter unnecessarily.
No, my lord,
Time again, no.
my lord, we are ad item on this, my lord.
If you are ad idem, then we are passing orders. We'll direct the special officer is there.
Yes,
We'll direct the special officer to complete the registration.
yes.
And
The deed which was shared under the cover of the
this bracketing modification, this is that bracketing.
Yes, that is the clarification has been given by the single bench, my lord.
on 15th. Deed which was given a cover of the letter
Yes.
of
And my lord, the deed and the query was given under cover of letter of the special officer dated 29th of April 2025.
this has to be registered.
My lord, I was humbly beseeching, my lord, will
No,
kindly grant a short
for-
pass. My lord,
sorry,
he'll be here, he'll address your
First
lord.
matter, no. We recorded in our order dated November 19, 2025 that the parties are ad idem on the registration of the deed of family arrangement and assured the court that they will take due steps for vacating modification of the impugned order. Full stop. We had adjourned the ground on such basis, awaiting any order which may be passed by the learned single judge. Who's up next para? Learned senior counsel appearing on behalf of the appellant hands over a server copy of an order dated December 15, 2025, passed by the learned single judge in connection with the suit, wherein it was recorded that the interim order dated August 21, 2025 was modified to the extent that the said order shall not stand in the way of implementing any order passed by the division bench in APOT 7 of 2024, comma, of which this bench is now in season. Full stop, next para. Accordingly, comma, learned senior counsel for the appellant also submits that a query was raised before the Registrar of Assurances, Kolkata, comma, a copy of which is also handed over in court today. Full stop. Hence, comma, there cannot be any further impediment in execution of the registration of the deed of family arrangement. Full stop. Accordingly, should he dispose of the GA?
Appeal also.
Appeal also. EC also goes.
Yes, yeah, the appeal is from the EC.
Oh.
Your Lordship, I
The
think
EC we cannot say it goes. The Learned Singh judge said.
Single bench is in scene of a partition suit.
Acha.
So that is a separate suit, my lord.
EC,
EC is arising out of this
Award.
award.
but yes.
Lordship, the order in appeal is out of that EC.
Out of the
Yes, Your Lordship. Your Lordship, we had
The
just-
EC, there is no question of disposing of the EC.
no, Your Lordship, because EC is disposed of.
Disposed
yes,
of already.
from
The appeal is against.
Yes.
from the EC one.
Accordingly, APOT 7 of
Your Lordship, only one prayer. Your Lordship had said that the special officer cannot execute the deed on behalf of the deceased persons. Your Lordship, only there was an order passed by the Honorable Justice Shoman Sen when he passed an
execute the deed on behalf of the deceased.
deceased, Your Lordship.
Cannot be done.
Your Lordship, then those persons who were there at the time when this family
Their heirs are not part of
their
it.
heirs are party. So Your Lordship will grant that the heirs can sign on their behalf.
They are signing on their individual
Individual capacity, but those two persons whose name is still
No
appearing.
longer in the world of the living.
Yes.
Yes, Your Lordship, but
How can someone sign on their behalf? We don't understand this concept.
then there, because in the previous family
It's
arrangement,
not even a legal fiction. This will be a legal figment of imagination.
the- and
Can a deceased person, if the deceased person today
Then the
cannot
name-
sign, how can someone else sign on his registration? We can understand.
for
but-
registration purpose, Your Lordship, those two
Very
persons whose name is
But
appearing.
for the purpose of registration, also there is a time limit within which.
My lord, what my learned friend probably wants to say, if your lordship sees page 2 of the deed, draft deed, which I have handed over under cover of letter,
Yes.
kindly see, my lord,
Who has died?
the father and the mother has died. So, my lord, it has been written, Mr. Deepnaran Mitra,
Yes.
appointed by order dated such and such for and on behalf of estate.
State of Kusum.
Or
Sagar.
estate of
Estate of Vijay
Kusum Sahiba
Kumar.
is referred to as the fourth party.
So that would cover it.
That is
Your
what-
Lordship.
so
If
this
it's
better-
the estate,
yes,
Your Lordship.
then it did not be done on behalf of anybody.
exactly.
State
So that has been
Then
taken
the
care of.
special officer will sign. Only one more thing, Your Lordship.
Special officer will register the deed, and the appellants will pay for this the registration fees.
Both of us.
Both will share equally.
Share
Yes,
equally.
schedule.
Your Lordship, there is one
Oh,
company
kindly say
also.
deed shared under cover of letter dated 29th April.
That was the final.
Can you show me?
Under cover of letter dated.
29th April 2025.
Your Lordship, only one thing, if Your Lordship can mention, the family arrangement is with regard to two scheduled properties.
No.
Schedule 2 and Schedule
Whatever
3.
is there in the family
Whatever
arrangement,
is
we would
Your
touch.
Lordship, whatever the special officer has done, Your Lordship, then as per the special officer.
Yes, I'm saying this deed.
Accordingly, APOT 7 of 2024 along with GA 1 of 2024 are disposed of by directing the special officer who has already been appointed to take immediate steps for registration of the deed of family arrangement in question. Full stop, the
Which
stamp,
has been circulated under cover of
comma,
letter.
which has been circulated under cover of the letter dated April 29, 2025. Full stop. The parties shall equally shall share equally the registration charges, comma, fees and stamp duty for the purpose of such registration. Full stop. No address to costs.
Obliged.
One sentence.
Costs.
No, one sentence.
Yes,
That I shouldn't be doing this.
Yes,
Lord,
yes.
After the order. Lord, regarding the companies, there is infighting between us. So, Lord, what would, if the company, normally, Lord, directors will not authorize one person to sign. But in this case, because we are fighting so much, we won't be able to agree.
Company is not a party. No. Kindly see, my lord.
To the deed, the company is a party to the deed.
Confirming party.
confirming party.
Confirming party.
So, my lord, if the special officer signs on behalf of the companies, then the problem will be solved.
Whoever is in the board, my lord, of the respective companies.
That's the problem. My lord, it's all between the two of us, and we are in litigation in NCLT regarding, my lord,
Whoever has the power now in law to sign for the companies, they
Lord,
will sign.
this itself will become a contentious
Why?
issue. Because, for example, my lord,
If it becomes, my lord, we will
it
come.
will be just only ensure it will
I
never.
will-
This
I
is
will
what
not
they've been
agree
Add
trying for
anything
7 years.
to the agreement between the parties, Mr. Chaudhary.
It will not happen, my
My
lord.
lord, we also, my lord, say that
Company, whoever is on the board, or say
the both of
authorized
us will
signatory,
go and contend that we are entitled to sign. For example, my lord, in
then
some
both of you sign. You are agreeable.
let that happen, my lord.
Yes.
That both of us will sign on behalf of the companies without prejudice to our
Let
rights.
us not
That
say
is
anything.
fair.
I don't think.
That
let
is a
let
fair
us not
suggestion.
preempt a dispute. Let us not
We
preempt
won't
a dispute.
add anything to the agreement.
If contingency arises, my lord, we'll have to disturb.
Then
the
we'll
election.
come back again to your lordship if the problem arises. We'll try to seek a
Yes.
solution.
Obviously, we'll.
But I appear, my lord, for the KMDA, not the state in this matter.
State is a party here.
Yes,
Yes,
it is
yes.
a main party.
State is the main party.
You
KMDA
do
is
that,
the-
Mr. Datta. Should you do that?
Because
You were there.
no. Problem is, my lord, before it had happened,
There is a conflict of interest between the state and the KMDA. You can appear for both.
Because
I can, but since
It
Mr.
would look very odd. I mean, the learned advocate general appearing for one of the parties, but not the state.
because the state
You
is the
present in court, and you're representing a party, private party, and you're the advocate general, Mr. Datta. That
No,
would
I'm
look-
representing the KMDA in whose favor the state had executed initially the license, then the lease.
requiring body. The KMD
Then
is
you
the
can
requiring
represent
body.
the state also. What
The
is it?
acquiring.
You can represent both. There is no conflict of
Yes.
interest. Otherwise, it would look very, I mean, we cannot force you to do that.
But what
It's your
happened?
choice. But
Before I assumed office, my lord, I had appeared for KMDA in this.
no, you appear for both. No difficulty. But state, you are there, and
Very well.
yes, Mr. Roy. What is it?
Well, this is the writ application was filed by the petitioner before lordship, challenging the acquisition in respect of property which is Korsba. Our condition is that the property, the subject matter dispute has never been acquired by the state.
It's acquired under which provision?
Yes,
LA
Act
Act.
2 of 1948. Now, if your lordship takes, I am from the judgment, I will satisfy your lordship. The trial, honorable sitting judge was
Act 2 of 1940 দেখুন তো এটা আছে কিনা দেখো তো এটা আছে কিনা requisition and acquisition West Bengal
West Bengal Requisition Acquisition Act.
Bengal Land Requisition and Acquisition Act 1948.
May I hand over copy?
You have a
Yes.
no, we'll just check up whether 2 copies will be necessary for us. Give us half a minute, we'll just check up. Land Acquisition Act উপরে আছে ওটা দিয়ে রাখো তো।
West Bengal laws volume 2 contains that.
That is not with us. ওই ডান দিকের গুলো দেখেন, ডান দিকের ওইগুলো কি বই নেই। আচ্ছা এলে একটা একবার দিয়ে রাখো তো। লাগবে না কিন্তু তাতে। Yes, if you give us a copy. ওগুলো দিন।
হ্যাঁ, ঠিক আছে, জানলাম। দরকার হলে এইজির সাহেবের ঘাড়ে উঠে পড়ো যন্ত্রের উপর।
Yes,
আরে আমার যন্ত্রটা কাজ করছে না।
yes, sir. You are challenging on what ground?
That there is no acquisition. First, under the Land Acquisition Act, my lord, section 4(1) is can be made provided there is a notification under section 3(1) of the said act. Because, my lord, the act 2, unlike the other acts, my lord, there are two parts.
Not direct acquisition. First
First, requisition, because that portion is not available under the Act 1 of 1894. Because there is direct acquisition. For the requisition, there is a provision for the requisition, and once the government is of the opinion that it is required for the public purpose, then my lord, the acquisition section 4(1)(a) will be published. My lord, Kalitan, these 3 plots are subject matter of dispute: 3777, 3775, and 3788.
Please repeat the numbers.
3777, 3777,
3777, yes.
3775,
3788.
And
3788.
very well.
Because before my learned friend proceeds, I mean, some digital difficulties. Everything has got hanged, my lord. I don't know.
You cannot access that.
No, everything has got hanged. I don't know why.
নতুন কিনতে হবে
নতুন কিনতে হবে
No. But can I come back tomorrow, Milord? Because I may not
Tomorrow
be
we
able
don't
to
take up these matters. We will take it up again next Wednesday.
kindly, but I'm so sorry, Milord.
We can
for making-
pass it over.
I don't know. Something has gone wrong. Morning also
Take help of your.
খুলছে কিন্তু
কি হচ্ছে
কিছুই
মানে
হচ্ছে
hang করে গেছে
হ্যাং করে গেছে এটা সিস্টেমটা হ্যাং করে
সিস্টেম হ্যাং করে
You can have it restarted.
Yes, that's what I'm doing, but I've done it twice. It's not
Give
working.
it to Mr. Abhishek. You do it.
learned senior friend is much more
No, he is very tech savvy. We know that.
tech savvy.
No, two brains are better than one. Only for that reason.
খুলে গেছে
We don't look towards our left because of obvious reasons. Maybe we can skip to Mr. Chatterjee, but not Mr. Rai.
There's something wrong.
See. Now you get to the relevant page, Mr.
Yes, it's open. It's open.
Okay.
and this is from the impugned judgment
So you say there could not have been any acquisition.
acquisition under section 4.1 in absence of any notice under section 3.1. Now, if your lordship, I can turn to page 67 of the stay application which I filed. This is a communication made by the Kolkata Metropolitan Development Authority. Page 67, my lord, lordship got it.
Yes. Yes.
This is a letter addressed to Prafullo Kumari Datta. My lord, you'll find address to enclosed. Please find one of the copy of the site plan.
Who is Prafullo Kumar Datta?
My predecessor.
My predecessor. The enclosed is find is one copy of the site plan showing the plot pertaining to pre-July 1978. Structure of Srimati Prafullo Kumari Datta under Mouja Kosba 3775, 3777 and 3788. Well, you'll find these are the three plots subject matter dispute between this. As sector ABC under East Calcutta Area Development Project. The name of Srimati Prafullo Kumari Datta appears in the list of pre-July 1978 structure owners within East Calcutta Development Project prepared by CMDA and legal or non-official members of the members of the East Calcutta Advisory Committee. The plots have been demarcated in consistent with the approval of the layout plan of the East Cell project. Clearance for exemption may be furnished after due verification of the original deed, other related documents in respect to the structure from your end. So this was the intimation given by the authority, my lord, can consider in the year 1996. Now, if your lordship, I can turn to page 69.
Yes.
This is the letter issued in the year 1999. My lord will find at the right hand top. It was also by CMD at that point of relevant point of time to Prafullo Kumari Datta. Whereas I am directed to refer you, directed to refer to your letter dated such and such on the subject mentioned above and to inform you that all the plots of land Mouja Kosba have been decided to be brought under preliminary notification under section 4 of the Land Regulation Act 1894 to 16/5/1995 for the years. So therefore, my lord, if your lordship may pause there for a moment and
Requisition Act 1894.
Act 1 of 1894, it should be the Act 1 of 1894.
It should have been Land Acquisition
Land
Act.
Acquisition Act, Act 1 of 1894. My lord, your lordship find this relates to the aforesaid three plots. At the top, your lordship find the plots number I mentioned. So even if my lord Kali in the year 1999, the authority is coming forward and said that we are taking steps for notifying the plots for the purpose of acquisition of 1894 Act. Now, if your lordship may kindly turn to that we have taken inspection. Page 75. Your lordship kindly turn to page 75.
এটা না পরের একটা এই একটা আনতে এই একটা ওয়েস্ট বেঙ্গল লজে আছে ওয়েস্ট বেঙ্গল লজ যে সিরিজটা আছে তাতে পাবে পেজ 75
Yes, my lord.
দুটো কপি 25
This is the legible copy. The 76 is the original one. 75 is the legible copy I have annexed, my lord.
রাইট
Now, your lordship, the undersigned is pleased to fully cancel so much of the mistake order of requisition dated 73-74 under section 3(1) of West Bengal Land Requisition Acquisition Act 1948, which was served upon the interested person between 2/5/1978, 10/5/1979, and last
14.
one, my lord, can turn to 26/8/80 ওইটা কত আছে?
22nd of April to 1980. ওটা ইলিজিবল আছে
2480 হবে না গো দাদা, 26/8/80 আছে তো, এটা কি একটা?
এটা ওরকমই অরিজিনাল কপি তো একটু ইলিজিবল
So these are the plots. My lord, pause there for a moment, and my lord, can you turn to the right hand column? Babu Datta, son of such and such, was recorded as the owner in this plot of land. Now pause there for a moment. Now we came before this honorable court and said that without acquiring the same, without any notification of the section 4(1), the state government or the KMDA has
they referred to an order under order of requisition.
yes, that my lord will not find that notification. I'll come to that, my lord. Now, my lord, this is the case which we made out in our
The date is also again very vague, 73 to 74.
all the notifications recalled. Now, my lord, kindly turn to
সার্ভড অন পিরিয়ড 70
now if your lordship kindly turn to the stand taken by the state, that your lordship will find, turn to opposition এটা কোথায় বল?
But you were never served any order of this sort.
Now, my lord, kindly turn to page 99, the stand taken by the KMDA. Before that, my lord, can you turn page paragraph 97, my lord, forgive me, my lord, 97, page 97. This is a part of the opposition filed by the
Yes. In the writ petition.
writ petition. Paragraph 9 is the relevant portion, my lord. I'm skip on the next page. I say that since the land, next page at the on the top I am placing, my lord. I say that since the land has been acquired and possession has already been handed over to CFDA and proper compensation has been paid at this stage, the performer respondent having no legal right to claim as the owner of the suit land. I further say that the acquisition of the aforesaid land is in full and final long back in 1976. Pause there for a moment. So this is the specific stand taken by the respondent authority. The acquisition has completed in the year 1976. Apropos to the letter which was written by them in the year 1999, where said that contemplating to issue notification under section 4(1)(a) for the purpose of acquisition of those land. Taken the position on 18 December 1973 and compensation has been paid to the awardees. Therefore, the communication dated 12 November 2000 claimed to be the furnished by the public information officer, being the deputy secretary, such as have no legal and validity at all. Even information supplied by the said officer of the CMDA cannot be treated as a valid.
What information was supplied?
Yes. 1997, that your lordship will find at page. Wait.
97
97. 2007. If your lordship can turn to page 80. Volume করে দিয়ে না আরো
This is 1611.
16/11/2000.
They refer to 2211.
Yes, sir.
the date mismatch
This will be the dates. This is the only right information, and this is the letter subject to correction.
No, this is your letter and next page is the information.
Replies. Page 80 is the reply, my lord, will find.
81 is the reply.
Yes, my lord. 81. It is electrical.
81 is
Reply.
the one they referred to.
Yes.
What was their answer? What was the question and what?
Typographical mistake for it. Page 22nd November.
But that letter is not there. They referred to a letter of some deputy secretary which is annexed to this. That is the information supply.
That is page 80. Subject it has wrongly been considered typography.
Typography.
Achha, very
आगे
very.
R is the number such and such. My lord, information middle portion, my lord, I'm reading out for your lordship, my lord.
Have been acquired. Fully.
Acquired fully in LA case number 1774 for the purpose of implementing the various relevant works within the such as the development project. All the particulars obtained from the available office record.
Why do they say this is wrong? Having no legality and validity?
I do not know. So this was the first time we came to know about this acquisition process.
No.
But the state, I do not know what is the reason for that. Is why precisely I am drawing your lordship attention. What is the reason for saying that these have no legal and validity at all? It is the authority himself they are coming and saying yes, it has been acquired in the 1976. The case made out by the state and the authority is that yes, it has been acquired in the 1976. Be as it may, my lord, this is the information given.
No, they say that it was
acquired.
Acquisition was in the year 1976.
Yes.
And CMD took possession before that in 73. And they say the same thing in this letter. The numbers are stated as have been acquired fully, such and such. They give a case, it gives a case number.
Yes.
Of 73, 74, which also corroborates the stand that 73 it was taken.
Yes.
So why do they deny? We don't know. No legality, validity. Anyway, Mr. Datta will be explaining that. Anyway, so this,
now,
this was a state's opposition or CMD?
KMD, my lord.
Very
now, my lord, can turn to paragraph 11, page 99. Page 99 of the paragraph 11. I say that, my lord, from the middle portion of this, I say that in paragraph 10 of the writ petition admitted that the respondents are in possession over the land in concern. Therefore, the claim of the petition is not correct, that the land has not been acquired. KMD, after taking the possession in the year 1976, pause here for a moment and my lord, can you reconcile with the
previous, doesn't tally with previous paragraph.
It is 73. According to them, they have taken the possession in the year 1976, 73. And now they are coming and saying in the year 1976 are in absolute possession of the said apportioned land. The claim of the petitioner regarding the non-service of notice at the time of acquisition proceedings is not correct, as because the predecessor interest of the petitioner received the compensation of the suit land. Pause there for a moment. So this is the admission that the award was declared and the predecessor of the petitioner received the compensation. Now, I can turn to the order impugned one. Paragraph 36. Of the impugned order, my lord, paragraph 36.
Yes.
In his next claim of submission, my lord will find, Mr. Mahata draws attention to this court to paragraph 1 and 2 of the instant petition vis-a-vis genealogical tables as mentioned in annexed at page number 19 of this instant writ petition. It is submitted by Mr. Mahata that the pleadings of the writ petition are absolutely incomplete, in as much as there is no averment in the writ petition at all as to how predecessor interests of the present writ petitioner Prafulla Kumari Datta became the owners of the aforementioned 3 plots. Pause here for a moment and my lord can relate to the averment made by the CMD regarding disbursement of the award in favor of the predecessors of the petitioners. It is further submitted by Mr. Mahata that there is no pleadings at all in the instant writ petition as to how the writ petitioner inherited the aforementioned 3 plots of land as claimed to have been owned and occupied by Prafulla Kumari Datta, My lord, my name was recorded and it is a government standard. I have shown to you a letter from where it will be crystal clear. It is a record in the of the office of the respondent authorities. The Prabhu Kumar Dotto's name is appearing in the record of rights, be as it may, and also as a recorded owner in those plots.
That is regarding a predecessor, but
Yes, Prabhu Kumar Dotto
submits that you have not shown that you are her heirs.
geological table. Yes, that is what, my lord, geological table, if you logically consider.
Very well.
Now, if you logically consider 36 and 37, in 36 they say the honorable single judge was pleased to opine that how the predecessor interest is
So this is
present.
the submission being recorded.
Yes, on the basis of which, my lord, can you turn to the finding.
Yes.
Paragraph 55.
Yes.
As rightly pointed out by Mr. Mahatab and Mr. Dotto, that in support of the claim of ownership of 122 katas of land, the aforementioned 3 RS plot numbers, the writ petitioner has not produced any document of title to substantiate as to how the predecessor of interest of the writ petitioner, namely Prafullo Kumari Dotto's disease, became the owner of the said 3 plots of land in the aforementioned 3 plots. So it rather appears to this court that relying upon page number 20A, 21A, and 22A being the copies of the ROR, the writ petitioner made an endeavor to substantiate that the name of legal of her said predecessor in the interest, namely Prafullo Kumari Dotto's disease, was recorded in the RS record as Rayat. At this juncture, if I look at page number 16 to 25, the affidavit opposition has filed on behalf of the state, it reveals that the aforementioned 3 plots land were not at all recorded in the name of said Prafullo Kumari Dotto's disease. And on the contrary, same has been recorded in the names of defined persons to the extent of their share. My lord, pause here for a moment, and my lord, I am drawing lots of a kind attention to the documents itself. আমাদের আরো একটা হচ্ছে ভলিউম 1, my lord, page 50.
পরপর আছে 50
না এটা দর্শকে দেখা ইয়ে করতে হবে।
এখানে আছে প্রফুল্ল কুমার দত্ত, তারপর তোমার নেক্সট হবে
My lord, this is the, my lord, got it, page 50. This is, my lord, Raj Sthitiban. Status is Raj Sthitiban, and it was vested to the government. That is why, my lord, Bharat Sarkar, it has been mentioned.
Prafullo is not legible here.
Yes, my lord.
Kumari Dotto is.
পরেরটা এলিজিবল হবে।
Legible. Next, page 54, your lordship find. This is
পরিষ্কার
legible.
আছে লেখাটা।
Page 54, your lordship find.
প্রফুল্ল কুমার দত্ত।
Yes.
Raj Sthitiban.
তিনটা প্লটই ওই একই।
Oh, these are the 3 things, my lord.
আরেকটা পেজ 58
From that, my lord, can you turn to page 61?
খাজনা
Who are paying the khazna? Prafullo Kumari Dotto. This is the receipt. Be as it may, it does not create. I have to show that yes, I have, in terms of that record of rights, I have acted upon.
61 is not legible.
62 টা টাইপ
62 is the
টাইপ কপি।
Very well.
না এরপরে স্টেটেড ডকুমেন্টস গুলো স্টেটেড না তো আগেরটা থেকে দেখিয়েছিলাম। Now, my lord, can you text of this
62 is a translation.
translation?
63 এর
The original is not legible. How could
63 তে তাও বোঝা
someone translate?
63, your lordship, if you logically turn to
63 টা তাও বোঝা যাচ্ছে প্রফুল্ল কুমারী দত্ত।
63, left hand side, my lord.
63 is.
Projar. Now, my lord, can you turn to the documents which filed by the state? Page 106.
Yes.
Who is the Upanishattar Malik, my lord, your lordship will find? Receiver Ramlal Mondol. Pause there for a moment, my lord, subject to question, my lord. After the extraction and registration, whether the Upanishattar can be remain in the name of, because it should be the government itself, by the collector. Be as it may, my lord, it was considered by the authority itself. And now, my lord, the status has been changed to Rayat Mukhari Sthitiban. And the certain persons' names are appearing. Now, my lord, can you consider this came up under the Proceedings Order 44 to of the Extradition Act. this anomaly was brought before the authority. The authority initiated suo motu proceedings. My lord, kindly turn to that portion, my lord. I'm drawing a lecture, page 157.
ওয়েস্ট বেঙ্গল স্টেট অ্যাকুইজিশন অ্যাক্ট এখানে আছে, একটু রং চঙাগুলোর মধ্যে। Which page?
Page 157.
Yes.
Well, may I read out though it is where it has been brought to my notice that finally published Khatiyan number such and such. 368, my lord, will find, my lord, this is the Khatiyan mentioned in my arrest record of rights, Khatiyan, of the Moja Koshba such and such, has been incorrectly made, has been illegally and or fraudulently tampered with a did, and whereas it is considered necessary to examine records and connected papers, it is ordered that DA to put up the such and such papers for my examination on such and such date. So it is the privacy satisfaction of the authority that this record of rights has been prepared or tampered in some other way. Now, my lord, can you next order your lordship will find? Examine the record of rights and connect.
This was the records of rights you produced.
Yes. Now it appears, well, the first record of rights I produced where it is Raj Sithiban.
Regarding that, this is being held.
No, the state has also produced the record of rights. I have shown to your lordship the Mukherjee Satto and Ramlal Mondol was
What
the.
was the ultimate decision? Corrected and.
Yes. Well, can you turn to? It was held that Ramlal Mondol, whose name is appearing, cannot be, he is the receiver.
Page 167, আমাদের recording
No, let us see the culmination of this.
Yes.
Notices have been duly issued to you also.
Yes, yes. Everybody appeared. My lord, can you turn to page 167?
No, why was notice given to you? Unless it referred to your.
Yes, both the Khatiyans are before the authority concern. That is why that anomaly is kept up and it found that subsequently that a new Khatiyan.
You approached the.
Yes, approach was made. Suo motu, that is why the suo motu process, it was placed before the authority and suo motu proceedings was initiated. My lord knows, my lord, order 42, order 44. Not section 44 2A, there is a limitation at the instance of the party, but the authority can suo motu can initiate it. That is why a suo motu process has been initiated, which is a pretty long time after the final publication of the correction. Now, my lord, if your lordship can turn to page 167. My lord, your lordship, there is a round mark is there, my lord, it should not be there. That Prafullo Kumar Dotto, your lordship will find 1, 2.
Yes.
Second paragraph, my lord will find Khatiyan number 115834 and 689.
These are different plots.
No,
this is a plot. This Khatiyan number. This is not a plot. This is a Khatiyan number.
Yes, Khatiyan number.
Prafullo Kumar Dotto, my lord will find. Right hand.
What is this? What is held here?
Here, the name of the Rayat. After considering all the records, my lord, this is the
name of the Rayat.
Bharat Samrat, because the receiver landlord will be Bharat Samrat.
Proper confusion.
Now, my lord, can you scribble next 168? On other hand,
yes.
On the other hand, other parties, legal heirs of receiver Ramlal Mondol, present during hearing and state that Ramlal Mondol's name recorded as superior landlord on the strength of valid document, but failed to produce the documents to establish their claim. They only produced a receipt of the fees deposited for such for the
years of receiver.
Yes, he was and some
under what I mean only court order.
High court order.
That is not reflected. এখানে একটা order আছে কিন্তু এটা কি connection ছিল
সেটা জানি না.
Anyway, very well. Then his heirs could not do anything. Receiver's heirs are not.
Receiver also cannot be. Now he has converted to Upanishatto.
But his heirs, I mean, what is the use of hearing that?
And my lord, can you consider subsequently what it was held? The illegal transfer has been effected. My lord, can you turn to page 170? Verified RS Khatiyan number, last paragraph, my lord, I am reading out for your lordship, my lord. Moja Kashba such and such. This is a Madhya Khotian recorded in the name of Ramlal Mondol, but careful scrutiny
of the
of the Khotian discussed that the Ramlal Mondol are a receiver of the rent receiving interest, subordinate to RS Khotian number 30. No reasons appear to have been admitted to the recording 16 on a share in favor of Ramlal Mondol. The tenancy deemed to have been owned by the receiver of the for realization of rent from the subordinate tenants. Drawing date of vesting. The RS Khatia number 30 of the same Mausa was recorded in favor of Ashok Properties Limited, who was the proprietor of the entire estate. This Khatian was owned by Adhar Chandra Das and others with the date of vesting, that is on 14/4/1955. Be that is and that as it may, it appears to have been error apparent on the RS Khatian number 1267 of Mausa such and such, under which is corrected accordingly. My lord, why this was considered in that way, that are also coming. It is Revenue Officers President 44(2) on the Estate Action Act in respect of the jurisdiction. This moja falls within the said jurisdiction. And the first, my lord, will find the other plots of land are not falls within this jurisdiction. So negotiation cannot be passed, but it is held that Ramlal Mondal cannot be the superior landlord. He is the only rent receiving interest. But this document has been produced before this court by the state, showing or disputing my title over the property in question. Where the under 44(2)(a), your lordship knows, my lord, it is an adjudication where it categorically adjudicated that this Dotto is the Rayat Sitivan and Bhar Samrat is the superior landlord. That I have shown to your lordship, that portion. Now, my lord, the Honorable Single Judge was pleased to opine.
No, owned by Ahindranath Das.
Yes, because it is a Radi Rashmani's property. After that, Ahindranath Datta is the last. Prior to vesting, he is the Jamindar.
জমিদার থেকে আমরা পেলাম
So,
সীতারাম রায়
we are the Rayat because it is the subordinate Khotian is there. If you logically consider the subordinate Khotian
Where
is.
have your name been mentioned here?
Beg your pardon, my lord.
Where has your name been mentioned?
No, my name has been mentioned in the beginning.
At page 167, it has been mentioned.
Yes, yes, that is.
What is the occasion of mentioning this? It is not
Yes,
preceded by anything.
that.
They are claimed by Shamulidas as their property. Oh, Shamulidas in this one?
yes. He is the instrument of this.
ওখানে অ্যাড হতে চেয়েছিল
Okay, I don't think she'll die. I'm scared while I go out.
But there is nothing preceding this chart.
No,
Straight away, this chart is given without.
are claimed to be a Samolidas as a property, such and such. The following. So therefore, my lord, the Ramlal Mondals cannot be come into the picture. Even assuming, my lord, now, my lord, I'll come to your lordship, secondly, the admission on their part that my predecessor received the interest. Now, my lord, can turn to the Honorable Single Judge presumption regarding section 90 and held that I have no title over the property of the Evidence Act. Paragraph 59.
No, this was not produced before the court.
Yes, everything was produced.
44 to A.
Yes. How it has dealt out, my lord, I'll come. Now 59. It appears to this court the jurisdictional BLRO is the custodian of original records of right. And such being the position, this court considered that the copies of RS record have been filed on behalf of the respondent state or not to be overlooked, giving precedence to the record of rights as submitted by the writ petitioners. Since the record of rights have been produced before this court on behalf of the state are public documents or more than 30 years old, and those are produced from the proper custody in terms of provision of section 90 of the Indian Evidence corresponding to section 92 of the Bharatiya Saksha Adhiniyam. Pause there for a moment, whether it is sacrosanct or not, my lord. I put this question to myself. This is a rebuttable presumption. When I pointed out before the court, Honorable Single Judge, yes, there is discrepancy. It is the discretion of the court to consider and allow me to revert the presumption. The presumption cannot be sacrosanct for the purpose of deciding any document. That was also, my lord's judgments are there, my lord, on that score. And after that, your lordship will find
in 44 to 8
yes, 67.
No, did they produce any document to substantiate that This awards have been declared, compensation
Yes,
paid.
that was there. That I'm coming, my lord.
Acha, let us complete this, then complete. Let us complete this.
Yes, my lord. Now, my lord, kindly consider paragraph 67. As discussed here above, my lord will find.
No, 61, 62 also the section 3.2 was dealt with.
Yes, but it was held that 4.1 has been issued, so it is presumed 3.1 has been complied with.
Hmm.
What the state is saying is, my lord, accepted in two sense. Now I can turn to 67. As discovered here, since the present petition is unable to produce a scrap of paper regarding her alleged title in respect of the aforesaid 3 plots of land, except are copies of the record of rights which may be called as a document of position. This court finds that the present petition got no locus standi to question the mode of acquisition or acquisition has been contended by Mr. Chatterjee in course of his argument. After that, everything is quoted, section 3 quoted. Supplementary written.
Yes.
Now, my lord, kindly consider paragraph 74 regarding the issuance of notice on section 3.
Volume 3, page.
Volume 3, page.
কবে হয়েছিল এটা আর ফাইল
হ্যাঁ
কবে হয়েছিল কোনো ডেট নেই
No, no. Now, my lord, a pro forma of section 3 notice was
This para 70?
paragraph 74, if a logical
74.
74, my lord, will find. Attested copy of the notice dated 30th November 2003 as published under section 32 of 1948 and also bears the signature seal of additional district magistrate Alipur at the internal page 2. Well, this is the section 3 notice for the purpose of showing that the acquisition was held sometimes in the 1976. Now I'll turn to the notice.
But there was a notice then.
So it is the case. Why not can you turn to the notice?
Page
Volume 3,
page 266
volume 3, page 266.
ফাইনাল হিয়ারিং স্টেজে সাপ্লিমেন্টারি এফিডেভিট দিয়ে এনেছিল
ভাগ কবে হয়েছিল ভাগ কবে হয়েছিল ভাগ কবে হয়েছিল 24 organized.
Oh, 83.
Now, my this is the notice purported to be issued in the year 1976.
But in the learned judge holds that notice dated 30th of November 2003. Attested copy of original notice dated 30th of November 2003.
The what has been annexed, my lord, can you turn to page
266
266
of volume 3.
of volume 3.
Yes.
And this is the notice which is produced as a authenticated copy of the notice which was issued sometimes in 73, 74. Apart from that,
No, the
at the
learned judge speaks about 2003.
now, my lord, at the bottom, my lord will find additional district magistrate 24 governors, Alipur.
No. Learned judge speaks of a notice dated 30th of
No,
November 2003.
No, there is no existence of 2003.
No, 2003, no notice.
Wrong, absolutely wrong.
হ্যাঁ এটাই তো দেখাচ্ছি
এটাই তো দেখাচ্ছে
এটাই তো দেখাচ্ছি
এটাই তো সাপ্লাই করেছিল
পেছন পেজে আছে
হ্যাঁ এটা তো অ্যাটেস্টেড করেছে
সেইটাই জজ সাহেব রেকর্ড করেছে
না নোটিস ডেটেড
তিনি এই ডেটটাই রেকর্ড করেছেন 11/2023 শোনা
Where is the attestation? It's on the reverse.
না না এইখানের অ্যাটেস্টেশনটা
Eight.
No, no, that
Next
is
page. Next page.
ওটা অ্যাটেস্টেশন না ওগুলো সিগনেচার অ্যাটেস্টেশন এটাই
This is the signature.
অ্যাটেস্টেশন এইটা
signature. There we don't find any date with the signature in our copy.
Here, on the right hand side, the next page, right hand side, 30/11/2020.
It's a different signature in our copy, page 267. Please take to 267, page 267.
67 possibly, my lord, is not the page.
Basically, এইটার কোনো pagination নেই।
It's not paginated in our
267
copy.
This is the
But after page 268, your lordship will find a supplementary affidavit.
And the most interesting your lordship will find.
No, no, let us first resolve this issue, Mr. Rai.
Yes, yes, yes. I'll come to that also.
side.
পুরোনো ব্যাগে
This is not what is being shown to us.
কোনটা?
My lord, your lordships may kindly come to page 269 of the paper of the stay application in the third volume.
এটাই তো দেখা
269, yes.
This is the supplementary affidavit. It starts.
260
Yes.
Because there is no running page number.
Ah.
Kindly take your internal page number 7
Wait.
7.
Yes, sir.
and thereafter, my lord,
Acha,
with
acha.
it,
Yes. Well,
Affidavit.
now, my lord, can you turn to this is the purported notice as per section 3(1). Initial notice, there is a copy. Next page, my lord, page 8. This is signature. At the middle portion, your lordship will find special land acquisition officer, my lord will find. My lord got it, middle portion. 24 Borgana South.
Page, which page?
Next page, page 8. Next page, my lord,
ইন্টারনাল
Page 8, yes.
at the bottom.
Yes. Additional
73,
district-
additional district magistrate 1973 and Alipur 24 Borgana South India 1973. Subject to correction, my lord, the South Transfer came in the year 1983.
আগে আসেনি তার আগে ফর্মটাতে কোনো সাউথ নর্থের ব্যাপার নেই কালীপুর
The previous form which has been placed before your lordship, it is without any signature. That is why there is no indication your lordship find that there is any district or not. This is a copy of the my lord will find. The next page, my lord. This is handwritten. Don't know the authenticity of the same. Even taken into account, my lord, this notice was issued in the 1973. Then what is the occasion on the part of the authority to put his signature as a 24 Borgana South LA collector, special land acquisition officer, when there is no existence of South 24 Borgana in the year 1973?
83 তে ফর্ম হয়েছে 86 এ অ্যাক্টিভ হয়েছে
It is the other signature is also not of 2003. That was a mistake on the part of the learned judge.
Yes, yes,
That
yes.
is also 73.
73.
All data-
73.
Only this within bracket South appears to have been interpolated because it was in 1984 when the
Yes.
this-
84, 86 unregistered. That is why your lordship, this document and 7, my lord, can you reconcile these two documents? Why I am saying, my lord, this is the pro forma which they've issued for the purpose of showing that the gazette notification under section 3(1) was issued. And at the bottom, my lord will not find anything regarding the north and south. This is a pro forma, that is without any signature. My lord will find this is a pro forma according to them.
দ্যাট ইজ অ্যাটেস্টেড
And that is attested
এই পেজে 7 এর বটম
same button.
অরিজিনালটাতেও সিগনেচার নেই
Original signature. So how it can be attested? Yes, no, I do not.
no, that was the reverse of this page.
Yes, according to them, these are the pro forma, and this was the portion of the schedule which has been directed to be handed over under section 3(1). Well, 3(1) contemplates the handing over position by requisition.
Yes.
So here, my lord, it is the 1973. This is the notification according to them, whereby and whereunder 3(1) a notice is issued, and these are the process of subject matter of requisition for handing over position to the authority concerned, the state. Now, my lord, can you turn to
3(1) is mentioned in yes.
yes, at the top, my lord will find But I'll satisfy your lordship from the forms itself. The forms have been there for the purpose of issuance of notice under section 3(1) under the Act 2 of 1948. Not only that, you have to mention when 3(1) was issued, because my lord, this is the date on which it was issued. My lord will not find a date on which this notice was issued.
অর্ডার ফর ডেলিভারিও ছিল না, ওনারদের উপরে সার্ভিস নেই, ওনারদের নামও বলা নেই, সব ফাঁকা, এভরিথিং ইন ব্ল্যাঙ্ক।
And it should be forwarded to the owner itself.
ওনারদের নাম কই?
সেটা ওটা পরে। Now the honorable signatures will proceeded. I have no locus to file this writ application on the ground that I have failed to prove my title. My lord, to some, so this is the application for injunction on that ground. My lord, I am submitting before your lordship. It is admitted, they have in their affidavit admitted the award money was paid to the money has been paid to the predecessor or interest of the petitioner. It is the admission I have shown to your lordship from paragraph 7 of the affidavit filed by them. If that be so, whether taking the advantage as admitted fact, whether I need to prove or not. Furtherance to the admission. The documents from their documents lying in the custody of the respondent authority, it proves that yes, Dotto's name is appearing in their records as a owner of this plot. 99, they have issued the letter in favor of Dotto. So presupposes, my lord, it is the case that at least the petitioner proves that yes, he is associated or his predecessor is one of the wrath in respect of the
How
property.
was section 44(2)(a) dealt?
Yes. That your lordship will find. এই জায়গাটা কোথায় গেল?
বলছি রিপোর্ট টু এ ডিল করেছে, ডিল করেনি আমার
না না, একটা জায়গায়
একটা
বলেছে,
জায়গায় জাস্ট
রেফার করেছে। Paragraph 30, yes, thank you, দাদা। এই
35
35 বললো, শুধু বলেছে,
শুধু বলেছে, আর কিছু বলবে?
এইখানে পরে আছে একটা জায়গায়,
35
এই যে
ডিল করেনি,
না না করেছে, একটা জায়গায় করেছে মনে হচ্ছে, আমি ওইটাই
তারপরে লোকাস চলে গেছে,
লোকাস।
আর সেকশন 90 তে ঢুকে গেছে এভিডেন্সে, ডিল করেনি।
The submission was recorded, subject to question on page 30, paragraph 35.
The state said that your documents are not genuine.
So at least, my lord. So how, my lord, section 90 can be invoked for the purpose of the rebuttal presumption? 90 has been exercised for the purpose of adjudication of my title based on a document which the same authorities say it is a manufactured document. On the contrary, my lord, state is relying upon the document which has been declared to be a document. The authenticity has been considered by the proceedings under section 44(2)(a) and held, no, this subsequent document cannot be considered to be a valid document. Now, apart from that, one can turn to the award.
Volume 2. Volume 2 আছে।
Volume 2, my lord, if I lost it.
Volume 1 আছে। Award that too.
What was your prayer in the writ petition?
That is the
To set aside acquisition.
it's quoted in the judgment.
Yes, yes.
prohibiting them to
Yes, because my case is that there is no acquisition. They have put up a board saying
file a title suit.
this is that is why 2007 document I produced before your lordship.
How can a writ petition be maintainable? These are disputed questions of fact.
Primarily, they have to satisfy there is a valid acquisition. Because they said that the acquisition has been effected in the year 1976-73. 2007, first time.
Sir, I should have filed a civil suit claiming that declaration.
But then, my lord, if that be so, my lord.
How can there be a writ of mandamus be issued or writ of prohibition be issued to take possession? Or this is purely a civil matter.
That is.
It is also civil, and the one.
So prayer D, your lordship finds because it is pre acquisition. That prayer I can make before your lordship and let it go.
No acquisition.
There is no acquisition.
Where is that?
Prayer
Prayer
D.
D.
Page 44.
Which page?
Page 44. That I can maintain before your lordship.
A prayer, I mean.
Why not a civil court? Because it's a pure disputed question of fact.
Disputed question
and complicated question of fact. Evidence has to be looked into.
Here, my lord, I could have understood that was considered. Here, my lord, my title has been disputed by the honorable single judge by holding the. Today, my lord, I am non-suited. Now, my lord, apart from that, my lord, can you consider the award which are the annex subject to correction, my lord? That is at page 116.
If you hold it is not maintainable, then all the findings go.
That's yes, but if I satisfy your lordship, there is no acquisition in the eye of law. Whether I am entitled to get this is even if assuming everything is correct. Can you turn to page 116? Page 119 is the relevant portion I am drawing your attention.
And 19.
Yes, this is the legible portion, my lord. The illegible portion is page 180. But where is the apportionment? I put this question to myself. It is there, award.
Your name is not there.
My name is, sir, even if my lord Kali consider my name is not there, everything is correct.
Basis of that.
Yes. Where is the apportionment? I put this question to myself. In absence of any apportionment, whether there is value award. So therefore, my lord, whether this requires consideration by your lordship or not, as on this day.
Section 3 HON'BLE.
So let them produce section 3 was done. I am out of court. The section 3 which they have produced is contrary to the record itself. Unless until there is a section 3.
Let us come back to that section 3 once more.
Yes, ma'am.
Page 266.
266, sir.
266 on the after page 266.
So that.
That.
Page number 7.
Page number 7.
Yes, yes, yes.
Then at the bottom, my lord will find.
That. But Mr. Rai, this calls for a scrutiny.
I am not on that.
No disputed, complicated disputed question of fact.
Not a complete. I could have understood.
The evidence was required to be taken.
Therefore, my lord, they must have the copy
How
of
could
3-1.
a declaration before a writ court?
Well, they must have the copy of 3-1A. My lord, I put this to myself. They must have the copy of the notice issued under section 3-1A. Under it.
We cannot decide that in a sitting in writ jurisdiction.
Well, they have not.
How can you decide the veracity of this document? Evidence was required to be produced. This was required to be brought on record by them also.
It is brought on record. On that they have relied upon
Original
this.
has not been brought. This is a photocopy.
Yes.
Original is required to be looked into.
That is why, my subject to question, if you are logically considered in other way.
For example, the age of the inks should have been. We should not give any clue to you, but the age of the ink at page 8 should have been tested regarding this insertion of South 24 Parganas.
That is why, my lord, I am keeping aside everything, my lord. Where is the notice?
What relief should have been granted to you? If you win this appeal, what relief should we give to you? Injunction and declaration.
Acquisition, free for acquisition. Whether this is valid acquisition or not, my lord, Kali consider.
Give such a declaration in writ court.
That I
And particularly in view of so many complex questions of fact being involved, Mr. Rai.
my
The single judge ought to have rejected on that ground, not maintainable.
it is held in that
You invited it.
the state invited my lord on that score, my lord. The document which has been declared to be a manufactured document.
File a writ petition seeking injunction restraining them from disturbing your position. And a declaration that the acquisition is not valid. Not maintainable. If we not go into all this, we'll just set aside the order on the ground that disputed questions of fact, subject to hearing, sir.
And only one thing, my lord.
Record your submissions. We have to record your submissions and Mr. Datta's submission.
And 3.1, where is the notice on the section 3.1, my lord? The state is no, it is not a notice on the section 3.1.
Is the format given under the
Format.
What's the format?
ওই বইটা দিয়েছি ওই
এই,
আমার বইটা দাও ওই আমার। এই যে ফর্ম 1 এর
Form 1. This is the format where your lordship will find. ওখানে আছে।
Form 1, yes.
yes absolutely different আর সই করছে কালেক্টর এ তো ডিস্ট্রিক্ট ম্যাজিস্ট্রেট সই করছে
Yes.
বক্তব্য অনুযায়ী absolutely different এই ফর্মের সাথে
And the collector is the authority. But be as it may, it has been signed. I am not on that also. Where is the notice?
এই কথাটাই নেই the owner occupier will deliver possession the land on such and such access
And there must be a direction for handing over position.
It's in form.
no to take possession where is the delivery
It is
of
in form, this form only.
No, my lord.
This is the form of the order.
Yes, the owner
Group
occupiers should
4
deliver.
says the orders under subsection 1 of section 3
Yes.
will be in form 1 and such and such.
হ্যাঁ
So this is absolutely in this form.
No, the owner's occupier will deliver position of
It's a
land.
copy paste almost of this, barring a few small exceptions.
Yes, those are there. Apart from that, the collector is the authority. But I have said that this is the format which has been used by the authority. But this notice, be as if I am not on that. Where is the issuance of this notice?
Writ court relied on this section 3 holding that this is correct. And therefore, your contention that there was no preceding section 3,
Yes,
which was your main ground, that goes.
well, this is the notice whether it absolutely signature of the authority, my lord, I can prove the. My lord, can you consider it that way?
How
It is
can
a-
the writ court decide even on these?
So let them only one thing, my lord. The certiorari is there, my lord. If a lordship can consider let them produce the section 3.
And what? Take evidence on the dock of the concerned persons.
Section 3.1 notice.
Cross-examine them. Have them cross-examined by you in a writ jurisdiction sitting in appeal. What are you saying, Mr. Rai?
Section 3 notice.
There is a subtle distinction between writs and
Section 3
not
notice.
so subtle in certain cases.
That's true, my lord. Section 3.
Purely a civil suit issue. How can we decide the veracity of this document without taking evidence, full-fledged evidence, if necessary by taking expert opinion?
And also the notice on the section 3 was not produced by the state. Never. What is the notice issued to the petitioners?
Let us see the language of section 3 once.
My lord will find 2. An order under subsection 1 shall,
Order shall be served
yes,
in the
in
prescribed.
prescribed manner on the owner of the land where the orders relate to the land in occupation, when occupier not being the owner of the land, and so on such occupier. A person failed to comply with the order of subsection 1, the collector person authorized him, writing on this we have to execute the orders as he consider expedient as may. Now, my lord, can you consider if that be so? So there must be address to the notice to any person. I could have understood that somebody's name, else names are there in the.
This order is to be served merely.
Yes.
No notice is to be given.
The
Section 3
precedent-
does not contemplate any notice at all. Not a notice. An order shall be made, that shall be served. in
Yes.
The prescribed.
To
This
the
order has been produced by them.
well, to
And it's of 1973.
yes.
I mean, there may not be documents of. I mean, why should we take a presumption against this? Presumption of correctness applies because this This order is there. This has been produced by the state.
This is a format. That is what, my lord, whether
It is
the,
always in the format. If
yes,
it's not in format, you are saying it is
been
not in
issued.
format.
It is, I could have understood. That is why
Clear order under section 3(1).
this is the format, and it is not
Number
inside.
is given of the case number is given.
Yes, without
Everything
any
is there.
signature. It is not.
Not what?
There is no signature of the issuing authority.
Signature is on the next page
No,
at the end.
my lord, can you consider then, my lord, it should be addressed to the occupier in terms of section 3(1)(2).
3(2).
3(2).
No, it should not be addressed there.
Yes, my lord.
An order under subsection 1 shall be served.
Prescribed manner.
The order copy will
on
be
the-
served with a covering letter.
Yes, shall be served in the prescribed manner on the owners of the land and where.
Yes.
My lord, that is why, my lord, precisely, my lord.
No notice is required. Notice is a completely different concept from an order being served, Mr. Rai. I make an order, serve it on you. I make an award, says serve it on you. That award need not be in the form of a notice. Awards are also to be served.
Yes,
That is not in the form of a notice. This is absolutely in correct format as per Form 1.
For what? Then, my lord, the must be communication. That is
Assumption of correctness should be there. It's a note document. You failed to call any handwriting expert or any other expert to ascertain the veracity. Presumption of you could not rebut the presumption of correctness attached to this official act.
But there is no signature of the person who have issued the same.
On the next page it is there. It's treated to be a whole
Then, my lord, if you logically
schedule. The schedule after the schedule it's there. Additional district magistrate's signature is there.
কোথায় after this? এখানে।
It is there
তো district magistrate এর power নেই তো।
at the end.
district magistrate এর power তো বলো না first বলো না। district magistrate power নেই বলো।
the district magistrate, whether, my lord, those are the things which you can whether the veracity of the section 3. My case was that there is no section 3. Whether the
I appreciate a view, correct view has been taken by the court. That in view of this, section 3 notice was there. Your ground in the writ petition was that there is it was
No
not
section-
preceded by
section 3.
section 3.
as on this, the state is not coming forward to say this is the date for issuance of section 3. Never, nowhere. In either in the affidavit, they said that 4(1) issued, it presupposes there is a issuance of section 3. So these are
এটা বলবে না? powerটা নিয়ে বলবে না?
Date is mentioned at the end.
no one is subject to
30th of November 1973.
No, this is not the issuance, my lord, this is a special.
Mentioned.
3 persons cannot, my lord, at the same time. My lord, it will be issued by the
The collector or additional district magistrate has been
yes, the power. One has been amended, my lord, your lordship will find.
signed.
1(a) has been amended.
Collector
came
has
into
to
force.
sign on the right hand side. He has
Yes,
signed.
yes, yes.
Maybe the date there is no place and date are not given, but that is a technical error. Not even an error, an omission. Inconsequential omission.
So this
And
is
yes, at the bottom, copy forwarded to that also has to be there. You have a point there
Yes.
in the form.
yes, because
That itself has to contain copy forwarded to. Although not a notice, that is also missing here.
it should be
Nothing
some
to show that it was forwarded.
nothing. That is the name of the person. Well, these are my
And
submission.
also the other grounds remain that 40
41(2) has not been considered. Section
there
19
are-
presumption has been taken.
the single judge has disbelieved your locus standi also.
Also, that is all the reason that documents which has been doubted by the authority itself. Record of rights.
এটা বলে যাও না।
কি?
authority-টা বলে যাও না।
The
ওরা
basis
বলে-
on which it was doubted is also wrong. You were saying.
Wrong.
Section 90 application.
Section 90 has applied for.
ওরা বলে যাও না।
এভিডেন্স একটা দাও ল্যাঙ্গুয়েজটা একটু দেখে নিতে
এই, যা, password নেই। অদিতি password।
আমি না,
হবে না।
আমি জানি।
this presumption was attached to this by the court to this section
Substantive record of rights.
record of rights এটা
records
দেন।
of rights.
Yes. And my lord, the judgment, if your lordship wants, I can produce the judgment, the discretion of the court. And here, my lord, I've disputed and privacy documents have shown
What discretion of the court?
that whether the presumption will be attributed to the
Court has taken used
yes,
this.
that means it should be discretion rebuttal presumption. Merely production of a
So
document.
how did you rebut it?
Yes, because
আমাদের আরে-
already himself said this is a
Oh, regarding the records, I'm confusing with section 3.
44.
This was regarding the records of it. So you have rebutted by producing the 44(2) is also there.
একটা বলে যান, ওটা বলে যান। বলছেন।
Due to some other matter? No.
Yes, yes.
Take it. Yes.
না, একটা পয়েন্ট বলে দেবো। ওটা বলবো পারতো।
While you are looking back, we have given you the liberty.
আমি বলবো কি?
Yes, Mr. Datta, what is it?
ঠিক আছে। কি?
Yes. If Mr. Mahathir is appearing for the state, we can hear him also. And you for the KMD. No difficulty.
Ready আছো?
No difficulty.
Ready?
We would like to pursue Mr. Datta. If you are appearing for the KMD, you can appear. We have no qualms.
No, no.
Yes.
তুমি কি বলবে তাহলে? না,
Then you cover both your cases. I mean, you are on the same footing because one is the requiring body, one is the acquiring. The state is the acquirer, rather.
my lord, before anything, please
Yes.
take, my lord, the affidavit in opposition of the state. Page numberটা বলো তো?
পাঠ্যদারগুলোকে সাইড করে।
Affidavit in opposition of the state.
পাঠ্যদার।
Where it starts at page 91.
Yes. 91.
My lord, the relevant portion, my lord, for this purpose, if your lordships may kindly take, my lord, subparagraph D under para 6.
Yes.
Needless to mention that as per deed and record of rights of the landowners, notice has been served upon all the recorded owners, and after initiation of due proceedings, the award was finally made for the entire area, including the land involving the present writ petition. Copy of record of rights. It is not out of place to mention that the lands which are involving in the present writ petition are also acquisitioned, and award in respect of this plots was published through award serial numbers 21, 13 and 20 in the year 1976 in favor of the awardee, namely Kalpana Mitro in respect of 3775, Ganesh Chandra Pal in respect of 3777, and Rajkumar Mondol in respect of 3788. Now, these your lordships would find at internal page 26A, running page টা বলো তো? Page টা বল? 26A, running page. Stated affidavit at 26A. Page numberটা বল না।
কোনটা বলো?
এই 26E of state seal.
অ্যাওয়ার্ড গুলো যেগুলো দিয়েছিল।
আর রাতের তো 24
একটু বলে।
Page 117. Page 117 maybe.
Yes. Eligible
117.
116 117.
But your lordships would find, my lord, in the printed one,
Yes.
where there is one serial number 21. The column next to that, first Nagendranath Roy's name is struck out.
Yes.
Just below that, Kalpana Moitro. Then below that, so and so, enter land value of 0.31 decimal of Shali land, plot number 3775E, interest plus such and such. On the right hand side, your lordships would find, then below that, apportionment plus valuation petition number so and so, award serial number 21, stroke plot number 3775, filed. On the right hand side, filed by Srimati Kalpana Moitro, wife, paid the awarded amount of rupees so and so. To Sri so and so, vide check number so and so. Then, my lord, skipping over one page, please take, my lord, page number 27A. কত হবে এখানে? 119.
Yes.
Here your lordships would find, my lord, again serial number 13. third line, Ganesh Chandra Pal, son of etc. etc. On the right hand side, your lordships would find, my lord, reference case number 542, place the decretal amount of rupees so and so, vide check number so and so as per ADM's order dated such and such.
Yes.
Then, my lord, going back to, my lord, the place where, my lord, I was, kindly take, my lord, page number. The states AO
96.
is 96.
Yes, you are placing 96.
Yes. Now coming back to, my lord, subparagraph E.
Hmm.
The plots involved in the present petition was acquisition by the competent authority and subsequently was handed over to the requiring body, being CMDA, now KMDA. As far back in 1976, the possession, including other plots, handed over to the requiring body. The award was made over and payments were also made to each of the awardee. Under the above state of affairs, the present writ petition ought to be dismissed. It is pertinent to mention here that after receiving
This
the
was the collector's affidavit.
yes, state's affidavit, collectors.
State's affidavit, yes.
Yes. Now, my lord, if your lordships may kindly take, my lord, the Act 2 once, because this is a proceeding under Act 2.
Yes.
But I'll come back to, my lord, Section 3, my lord, if required. Now, please take, my lord, Section 8. 8.
Yes.
The award is passed, my lord, under 7A. My lord, I skip over that.
Yes.
Please take Section 8. The collector shall, in every case where any person interested being aggrieved by an award made under subsection 2 of Section 7 or clause II of subsection 4 of that section, make an application requiring the matter to be referred to the court, or where there is any disagreement with regard to the compensation payable under subsection 3 of Section 7 between the collector and the person interested in compensation, refer the matter to the decision of the court. The provisions of subsection 2 of Section 18 and of sections 19 to 22 and of sections 25 to 28A of the Land Acquisition Act and the principles set out in subsection 1 and in clause A of subsection 2 of Section 7 of this Act shall, so far as may be applicable, apply in respect of reference made to court under subsection 1. Now, my lord, if your lordships may kindly take, my lord, the Act 1. Act 1.
Yes. And Acquisition Act.
Please take, my lord, Section 18 of Act 1. Subsection 1 of Section 18 is equal to,
One
with
minute.
some
এই ল্যান্ড অ্যাকুইজিশন একটা ওনাকে তো দিয়েছিল যখন প্রথমে চাই।
ঢুকে গেছে কি ভেতরে?
বুঝলাম না। ওটা কি?
এটা এভিডেন্স অ্যাক্ট, এস্টেট অ্যাকুইজিশন অ্যাক্ট।
একটা তো দিয়েছিল আমাকে। একটা দাওনি তখন? আমি চাননি বলে ওদের দাওনি তখন। Yes. Which section, Mr. Datta?
Section 18 of the of Act 1.
Yes.
But Section 18 provides that reference should be made to the collector. Subsection 1. I come to, my lord, subsection 2. The application. Application means application to the collector for a reference. Shall state the grounds on which objection to the award is taken, provided that every such application shall be made, etc., etc. This is the procedural part. Then the statement, then 20 onwards, will notice the scope of the proceedings, open court proceedings, etc. But I'll not trouble your lordship with that for the present. Therefore, my lord, The grievance today is at the highest that Section 3 notice was not served upon the petitioners or their predecessors. This is the grievance. First point would be, Millard, after an award is made, Millard, what is the scope of challenge? The only scope of challenge is if you are aggrieved with the quantum, you can go up for enhancement of the compensation. If you are aggrieved with the apportionment, again a reference is maintainable. If you are aggrieved with the persons to whom or in whose favor award has been made, again, Millard, it can go up for a reference. So, Millard, this is the limited scope of challenge, Millard, which is available, Millard, once an award is made. Now, coming back to the prayers in the writ petition. Millard, my learned friends, clients have not been able to, Millard, succeed in proving that there was no award at all. And Millard, your lordships have considered, Millard, the prayers. What is the prayer? The prayer D says that declare that it is free from accusation. Kindly comes back to Millard the prayers. It is quoted in the judgment.
There is no accusation.
Yes. Please have a look at D declaration, if necessary, that there has been no accusation proceeding and that the respondents never acquired right title interest.
They are not challenging the award as such. They are saying there was no accusation proceeding in the eye of law.
Now, whether, Millard, this can be done, Millard, but the scheme of the Land Acquisition Act is such, though, Millard, here, Millard, that declaration part is not available, but after a declaration takes place under the Act of 1 I'm talking of, but there is hardly any scope of any challenge.
Maybe in a civil suit it can be.
Yes.
The premise of the foundation of the
There has to be, they have to pray for a declaration.
Specific declaration.
Yes.
This same declaration that there was no accusation proceeding in the eye of law.
In the eye of law.
We'll just come back in terms. Yes, please.
Yes. Now, my lord, the complaint is,
Yes.
one of the complaint is that section 3 of Act 2 has not been complied with. But assuming for argument's sake, my lord, such a complaint could be made. Assuming for argument's sake, because my first submission would be, once an award is made, my lord, the scope of challenge is very limited. It is only limited to the scope that whether you are agreed with the quantum, apportionment given to a wrong person, these are, my lord, 3 or 4 grounds on which it can be carried forward, a challenge can be carried. The submission is that section 3 of Act 2 has not been complied with. Why? Because the notice was not given. But there is no ground in the writ petition, but still, my lord, I will not, my lord, say that, but please note it as a as a submission. Please have a look to me at section 3 now.
Yes.
But subsection 1 says that if the state government is satisfied that it is needed for a public purpose, then
Yes.
it can requisition. So this is the power to requisition. Now, please take, my lord, 1A. I hope my 1A is there.
1 is there.
Yes. The collector of a district and so and so, when authorized by the state government in this behalf, may exercise within his jurisdiction the powers conferred under subsection 1. An order under subsection 1 shall be served in the prescribed manner on the owner of the land, and where the order relates to land in occupation of an occupier not being the owner of the land, also on such occupier. If any person fails to comply with an order made under subsection 1, the collector or any person authorized by him in writing on this behalf shall execute the order.
They say under 2 there was no service of the order.
Yes. Now, first is where the order is before the court, my lord.
Order, they say that there is some discrepancy because South 24 Parganas was not there. We'll come to that later.
Yes, I very well. I'll take that also.
Yes, but first that this was you have produced nothing to show that this was served.
Yes. First is, my lord, the order shall be served.
Order shall be served. No notice is required.
Yes.
But order format says at the bottom, copy forwarded to such and such.
But
That's also missing there.
I take for argument's sake that it has not been served. Let us proceed on that.
Yes.
Because today, my lord, this disputed question whether it has been served, notice, this, that, etc. I don't think, my lord, the writ court requires to be troubled with that. I proceed on the basis that it has not been served, without, my lord, accepting that it has not been served. My lord, in the context of, my lord, section 9 of the of Act 1, which again requires a notice.
Yes. Emergency provisions.
Yes. Now, in those cases, a non-service of notice, the consequences of non-service of notice was, my lord, way back, my lord, considered, my lord, by the Mysore High Court in 1961. I would like to, my lord, place one judgment on that, which somewhat was echoed by the Supreme Court in 2010 in May George's case. I'll place those judgments. But the first one is 19. Now that we are more accustomed with online references.
Obviously, yes.
1961 SCC Online Karnataka 146.
Now, order shall be served in a prescribed manner.
Yes.
Is there any prescribed manner first before going on to the judgment?
Yes.
Is there a prescribed manner in any?
But in section 9 there is a prescribed manner.
No, under the rules. We'll just check that first. Form and
Right,
manner of
yes.
service. 4, rule
Yes,
4.
yes.
Rule 3.
Acha, rule 3.
এতে বোধহয়
Rule
rule,
3.
এতে rule 3 নেই।
Shall be
Acha.
served on the owner by delivering or tendering a copy. So direct service. If not possible, then fixing a copy on the outer door. No,
Correct.
or.
4 modes, sir. ABC.
But it has to be sent as opposed to section 9, where notice to be given only at the convenient places on the other land. So
But-
you are citing a judgment of section 9, Mr. Dotto, but that there is no parity between the two.
I'll come to that. Please have a look toward Rule 4 of the 1948 rules.
Yes.
But first is made the form, the orders under subsection 1 of section 3 and so shall respectively be as nearly as possible in form 1 and 5 appended to these rules, and the notices referred to in subsection 1 and 3 of section 5 and subsection 3 of section 6 shall respectively be as nearly as possible in form 3, 4 and 6 appended. The notice referred to in subsection 1A of 4, we are not concerned. Then Millard subsection, then rule 5. Now kindly take Millard form number 1.
Yes.
Whereas in the opinion of the governor, it is necessary for the purpose of maintaining so and so essential to the life of the community for transport, etc., requisition of the lands in the schedule below. And whereas the governor, by notification dated blank, published in the Gazette blank, authorized me to exercise powers conferred under so and so. Now, therefore, in exercise of power conferred in subsection 1 of section 3 of the Act, read with the authority so vested, the governor is pleased to hereby requisition the land in the schedule below and make the following orders, namely 1, 2, 3, 4. So, therefore, this is only an intimation that a requisition has been made. Now, if your lordships may kindly have a look to section 9 of the of Act 1, which has got serious aspects in it, or rather, Millard, some right attached to the notice made under section 9. Please have a look towards section 9.
Yes.
Notice is to persons interested. This is section 9 of Act 1. The collector shall cause public notice to be given at the convenient places or near the place land to be taken, stating the government intends to take possession of the land and that claims to compensation for all interests in such land may be made to him. Such notice shall state the particulars of the land needed, require all persons interested in the land to appear personally or by agent before the collector at a time place mentioned, such time not being earlier than 15 days from the date of publication of the notice, and to state the nature of their respective interest in the land and the amount particulars, etc., etc. So, Millard, a non-service of notice, but under section 9 of Act 1, may severely affect a person in the sense his interest over the land may not be brought to the notice of
Yes.
the authorities if a notice under 9 is not given.
Right.
Whereas in our case, it is only an intimation that a requisition has been done.
No, not merely that, because if that is not brought to his knowledge, then he does not have any of the options. I mean,
yes.
Although no hearing is required to be given.
Yes.
No hearing is required to be given.
Because as your lordships are aware, Millard.
Yes. Yes.
Act 2 was required despite Act 1 being in the statute book in the year 1948, immediately after independence, because Act 1 did not provide for any power to requisition.
Right, right.
Requisition was why required? Because post-independence, Millard, we required to construct road, airport, this, that, etc., for which the legislature felt that the entire rigmarole of an acquisition, if it is to be undertaken, then the basic purpose would get frustrated.
Temporary purposes also it would be required.
Yes, yes. Therefore, Millard, the power of requisition was required to be given. In fact, in our Calcutta, an old judgment, it has also been noted that when Act 2 was framed, the Constitution did not permit framing of any legislation for requisition. Therefore, Parliament, Millard, had issued a notice, which is quoted in one of our judgments of our court, which permitted the state legislature to frame legislation on requisition. Thereafter, only Act 2 came. Therefore,
I didn't know that.
if required in a case made, I'll place that.
Yes.
Therefore, my lord, Act 2 came. So we are, my lord, dilating at a stage prior to acquisition. That is requisition. So this notice, in my very respectful submission, does not confer any right, nor does it affect any right if not complied with. Because 3 requires only an intimation that the governor has requisitioned this land.
And in any event, Section 4 service has been admitted.
Section 4, there is no dispute.
4 is the
Actual
actual
transfer of title.
upon which they go on to make their claims of compensation
Correct.
also and all these things.
But the confiscatory part is 418, where you lose title or the vesting takes place.
All right.
Now please take, my lord, this judgment.
Yes.
1961 SCC Online Karnataka 146. Kindly take, my lord, one paragraph, paragraph number 5. It's a short judgment.
Yes.
As pointed out by this court in writ petition, the object of enacting subsection 3 of section 9 of the Land Acquisition Act is to afford to persons occupying the land or interested in it to make a claim for compensation so that the collector might decide the compensation payable to them and order its payment. If in the making of that claim or in its establishment, the omission to serve a notice under subsection 3 of section 9 has brought about a hindrance, it is clear that the person who was so prevented from making a claim or establishing it has a right to challenge the award by adoption of suitable steps for that purpose. It is, however, clear that there is no inflexible rule that an omission to serve a notice under section 9(3) always and in all circumstances vitiate an award. It is, however, unnecessary to pursue this discussion since, in the circumstances of this case, it is obvious that the case of every petitioner, other than the writ petitioner in so and so, it could not be said that there was any difficulty presented by the omission to serve them with a notice under section 9(3) in the presentation or establishment of a claim for compensation. Out of the 6 petitioners, 5 of them presented claims.
This is on the facts.
It's on the, in those circumstances, such. Now, but this 1961 principle has been echoed by the Supreme Court in 2010 in May George's case. Please have a look to this. This is 2010 Supreme Court cases. I'm sorry, 2010 volume 13 Supreme Court cases, page 98.
Para 14 to 25. 14, 15, 25 double করবেন 16 to
Have a look to paragraph 14, 1-4. Section 3 has does not give any opportunity. Section 9 gives. Then also kindly see what is the contention, the findings of the Supreme Court. Section 9 of the Act provides for an opportunity to the person interested to file a claim petition with documentary evidence or determining the market value of the land, and in case a person does not file claim under Section 9, even after receiving the notice, he still has a right to make an application for making a reference under Section 18 of the Act. Therefore, the scheme of the Act is such that it does not cause any prejudicial consequence in case the notice under Section 9(3) is not served upon the person interested. While determining whether a provision is mandatory or directory in addition to the language used therein, the court has to examine the context in which the provision is used and the purpose it seeks to achieve. It may also be necessary to find out the intent of the legislature for enacting it and the serious and general inconveniences or injustice to persons relating thereto from its application. The provision is mandatory if it is passed for the purpose of enabling the doing of something and prescribes the formalities for doing certain things. In so and so, Well, what is mandatory and directory, my lord, has been considered.
Hmm.
Paragraph number 16, my lord, the previous judgment is considered. 16 also same, 17 same, 18 same, 19 same, 20, 10, 21, 22, 23, 24. Well, these are all the judgments which will not dilate on which provisions are mandatory, which are directory. Now, please take 25.
Yes.
The law on this issue can be summarized to the effect that in order to declare a provision mandatory, the test to be applied is as to whether non-compliance of the provision would render the entire proceedings invalid or not. Whether the provision is mandatory or directory depends upon the intent of the legislature and not upon the language for which the intent is clothed. The issue is to be examined having regard to the context, subject matter, and object of the statutory provision in question. The court may find out as to what would be the consequence which would flow from construing it in one way or the other, and as to whether the statute provides for a contingency for non-compliance with the provisions, and as to whether the non-compliance is visited by small penalty or serious consequence would flow therefrom, and as to whether a particular interpretation would defeat or frustrate the legislation, and if the provision is mandatory, the act done is in breach thereof will be invalid.
They say, is it their stand that they're still in possession?
No, they are not in possession.
They're not.
They are not in possession.
But it was given to Haldiram. Please.
Whatever. Yes.
The instant case is required to be examined in the light of the aforesaid settled legal provision. In fact, failure of issuance of notice under section 9(3) would not adversely affect the subsequent proceedings, including the award and title of the government in the acquired land. So far as the person interested is concerned, he is entitled only to receive compensation, and therefore there may be a large number of disputes regarding apportionment of compensation. In such an eventuality, he may approach the collector to make a reference, etc. Well, please read Miller section para 28 instead of section 16 418 at paragraph 28. In fact, the land vests in the state free from all encumbrances when possession is taken under section 16 of the Act. Once land is vested in the state, it cannot be divested even if there has been some irregularity in the acquisition proceeding. In spite of the fact that section 9 notice has not been served upon the person interested, he could still claim compensation and ask for making a reference under section 80. There is nothing in that to show that non-compliance will be fatal and visit any penalty. Then where the Supreme Court goes on, Millard.
28 is not so German because upon section 16 being completed, possession being taken. But
Yes.
the
Here is a case where possession is first taken.
yes, so it's a reverse.
It's reverse.
It's like a section 17 LA Act
Right,
scenario.
right,
Possession
right,
is taken first
right,
and then.
right.
So therefore, section 16 does not come into play at all.
Yes.
It
But
vests in it.
yes,
It's requisition, actually, not vesting.
Yes. So in under Act 2, Millard, once Millard section 4 notice is issued and it is published in the Gazette, then Millard automatic Millard transfer of title.
So you are distinguishing between, because under this act there cannot be any direct acquisition. There has to be a prior requisition. That holds good.
Yes.
But their primary contention is that at the end of the day, no order was served on them. You say that is whatever you have said.
Yes.
That it is not mandatory because no serious consequences in the sense that they don't have any right of hearing or anything.
Right.
Only for the purpose of taking possession, because subsection 3 says if a person fails to comply with an order, possession will be taken. The magistrate will enforce the delivery of possession. So the only consequence is in you taking possession without them knowing.
Yes. At the most, Millard.
At the most.
At the most, I take possession. They don't know that there has been an order of requisition.
Yes.
That is the maximum.
Other rights are not
Yes.
affected at all.
Other rights are all Millard from section 8. Read with Millard.
4 onwards.
Yes.
Very well.
So, Millard, my very respectful submission is that, Millard, without accepting that there has been a non-compliance of section 3 of Act 2, Millard, that did not visit them with any consequences.
All right.
Well, and now, Milord, I come to the next part.
Hmm.
Milord, somebody is coming before the court and complaining that
Hmm.
my right over my property is affected for whatever reasons. Now, this right is sought to be enforced in court based on no documents or title. Milord, the entire proceeding is based on, Milord, certain record of rights, which again, Milord, the state had disputed the authenticity of those records of right. But the learned judge has given a finding on that you cannot claim title based on record of rights, and no scrap of title documents have been produced before the court.
But didn't you admit that title by sending?
No.
In opposition, everywhere you have said that their predecessor was given a notice.
Milord, dear
under
Lordship, may
Section
kindly
4.
have a look to this. Well, please have a look toward the affidavit of the state once more.
Yes.
But in the affidavit of the state,
Yes. We have said that on all the recorded owners it has been served.
yes. 4(1)(d).
D.
Sorry, this is subparagraph paragraph 6.
6D.
D.
Yes, we have seen the language. You are right. As per the then records of rights, the landowners were served.
Yes.
Recorded owners, and the names also you give. And even in paragraph 9, which was placed, you say that since the land has been acquired and possession has already been handed over, it's in abstract terms,
Yes.
not to them.
General.
Yes. Awardees, compensation has been paid to the awardees, very
Is entitled to.
But the records of rights, they had. Acha, we will go one by one. If you finish on this, then we'll come to 44(2)(a) also.
44(2)(a), Milord, my respectful submission would be 44(2)(a) is a subsequent situation.
Yes, but before the writ petition was decided.
But Milord, my acquisition is of mid-70s. That is why, Milord, on the recorded owners as on that day. But assuming that, Milord, 44(2)(a) is correct, my action, Milord, cannot be invalidated, Milord, by reason of a subsequent, Milord, adjudication, Milord, as regards title, if at all.
Yes. Admittedly, she died.
Milord, Profullo Kumari, Milord, had expired in the year 1950, admitted case. Therefore, nothing could have been done thereafter, I mean after 1950.
44 to 2005. To whether they are entitled. Yes, কেসটাকে একটু সাইড করে ধরেন, আমি কপি আনাচ্ছি, হার্ড কপি।
দেখুন
8 to 12. Who are entitled?
Yes. But only one judgment, but I readily don't have it, but I'm getting it as soon as possible. But you don't know.
What is the citation?
But it's 2009, volume 10 Supreme Court cases. This is page 664.
664.
But who is entitled to notices?
2009.
910 SCC
664.
664. May I read it, and then
Just give us half a minute so that we can follow with you.
I'm sorry, Milord?
Give us half a minute, we will follow with you. Yeah, in our
Oh,
tab, we
acha.
can.
8 to 12.
Eh. Yeah.
It is opening eternally.
Yes, nowadays, Milord, the internet services has become slow.
Yes, in our court, yes.
In some courtrooms, like now the present court number 26, we don't get any internet services.
Wherever I go, the internet service becomes poor. When I was in the other court also, court number 9, similar issue occurred. And so that is supposed to, haunt me. That has put me in trouble also previously, you know that.
Yes. Mr. Justice Kolanmai Ganguly used to recite a story that someone saw
Yes,
in the night, dead of the night,
yes.
courts being held in court number 10.
That may happen soon. After the recent spat of directions, we may be directed to do that.
But at the same time, your lordships have a lot of business after court hours also.
Most of the business after court hours. Sometimes we leave at 8:30, 8:45 also, but not daily. 7:30 at least, not before that. And if you want to dictate a part of the judgment, CAV judgments, then it's longer. And we have to leave our PAs also,
Yes.
because
So you are
most
alone.
of them reside
Yes.
in Chandanagar and
Yes.
those areas.
That is the hub.
That is the hub. So that's why then we sometimes allocate work in such a manner that we do the reading after that. So it's, yes. Which paragraph you said?
Paragraph 8.
8. Yes, we are there.
There is no obligation, again, we are under the Land Acquisition Act. There is no obligation on the part of the collector to hold an inquiry to find out whether there are any other persons interested in the land or whether there are any vested remainder men in addition to those whose names are entered as owners, holders, occupiers of the acquired land. Nor does the collector have any obligation to issue notices to persons whose names are not entered in the revenue records. Here, the admitted case is that subsequently it was rectified.
No, but Mr. Dotto, they have produced records of rights. We don't know of which period. We don't know about the period.
On that, Milord, I am not prepared. I'll be very candid because Mr. Mahato had made submissions on that. Whether at all, Milord, these records of rights could be believed. And Milord, the learned single judge has accepted the interpretation of the record of rights by Mr. Mahato. This does not mean that the persons whose name are not entered into the revenue records do not have any right to the acquired land or that they lose their claim for compensation. Their interest and rights in regard to compensation are protected by the provision relating to apportionment of compensation and provision for referring the dispute to a civil court for apportionment of compensation. Persons are believed to be interested in the acquired land if their names are disclosed to the collector as persons having interest in the acquired land, though their names are not entered in the revenue records, either in correspondence or otherwise, and whom the collector believes having an interest in the acquired land. The question whether a person is believed to be interested in the acquired land would depend upon the subjective satisfaction of the court. The collector is not expected to hold many inquiries to find out whether the persons whose names are disclosed, other than those whose names are entered in the revenue records, are persons interested in the acquired land or not. Therefore, no person has any right to assert that the collector should recognize him to be the person interested in the acquired land and issue notice to him merely because someone informs the collector that such person is also having an interest if his name is not entered in the revenue record. Of course, if the collector is prima facie satisfied from his records that someone other than those whose names are entered in the revenue records are also interested in the land, he may at his discretion issue notice to them. If he is not satisfied, he need not issue notice to them. Who is to be believed to have an interest is a purely subjective administrative decision. Such persons have no right to claim that the notice of acquisition should be issued to them. Therefore, we agree with the division bench that the notice of acquisition has to be issued only to those persons whose names are recorded as owners, holders, occupiers in the revenue records.
No, in this case, they were served with Section 4 notice. After that, they did not do anything.
Section 4 is not for sole service.
Section 4, what happens is Section 4 is to be published in the Gazette.
Generally, yes.
Gazette. Now, once Section 4 1A is published in the Gazette,
They have a right to compensation.
that they have, definitely. That they have.
No, they approached.
No. I don't do subject to correction by my learned friend. They did not approach. These three plots of land in the award has been, I mean, the compensation has been awarded in favor of three persons.
Others.
Yes, 6E Miller paragraph, this has been
Yes.
stated. They have taken the compensation. As Miller, your lordships were observing that this is a highly disputed questions of fact. But our case was whether a title dispute can be gone into in the writ jurisdiction.
You take that point before the writ court.
Yes.
Let us see that part also.
Yes. Please. Your lordships may kindly take, because most of the argument was advanced by Mr. Mahato.
We are following from the memo, so you can refer to the internal pages. From the impugned order, it should be.
Well, please take with para 46 of internal page 15.
Yes.
In course of his submission, Mr. Dotto, appearing for KMDA, while adopting the submission of Mr. Mahato, also questions the locus standi of the petition in filing the writ petition.
No, that is different. They have no title, that you said.
No document of title has been filed on behalf of the petitioner. It is contended that by no stretch of imagination, record of right can be considered as a document of title. It is submitted as a record of right, at best raises a presumption in regard to possession. Now, on the aspect that your lordships are
disputed question of fact, that no objection was taken by.
Because
No, straight to the merits and locus standi you took.
yes, paramilord 65. Internal page 20, bottom. Though in course of argument, Mr. Chatterjee strongly contended that page number so-and-so of the reply against AO, KMDA being copies of deed of license and a judgment and decree of the civil court entitled suit number so-and-so, it would reveal that in respect of the aforesaid 3 plots of land, title and interest of KMD are still imperfect either by their own admission in the said deed of license and or in the pleading in the suit. However, such contention is not at all accepted by this court in view of the fact that this court cannot adjudicate the title either of the petitioner or of the KMDA, since the adjudication of the right title interest of a party can be done by trial or evidence, which machinery a writ court does not possess.
67.
67 is different.
67
was
on
on your
locus,
argument, locus standi.
on locus.
Because they have not produced any title.
Yes.
Very good.
So these are more or less my submission, but on the record of rights, if your lordships considers.
We can hear
Mr.
Mr. Mahato if he wants to. Period of the records of rights, when these extracts were taken out is not clear from the order at least.
But there is a stark difference between the record of rights which is found in the records of the collector or the revenue records and what has been produced before the court. Ishu.
But then authenticity was, 44-2A proceeding is there. 44-2A has been allowed on the ground that the recording was incorrect.
But again, with 44-2A, Milord, your lordship.
As you said, it
Yes.
cannot retrospectively invalidate your.
Yes.
And you have cited the judgments also showing
Yes.
that.
Whatever is in the revenue records.
Just Mr. Datto, later on, if you can just hand over 2 copies of 2009-10.
Yes, immediate matter. Immediate.
Because all will be on the records. Otherwise, you can also check up online. No difficulty.
No, I'll.
But it will be in one file. So wherever we are correcting it.
But I'll ensure before your lordship rises for the research.
Yes, sufficient. Thank you.
May I have your leave?
Yes. Yes, Mr. Mahato.
If your lordship will kindly come, volume 1, page 50. Record of rights. First record of rights in respect of Prafullo Kumari Datta. A type copy is also there.
Yes, Prafullo Kumari Datta.
My lord. ভারত সম্রাট পক্ষে দক্ষিণ 24 পরগনা কালেক্টর
Right.
ভারত সম্রাট পক্ষে মালট it must be the CS not the RS and actually admittedly
yes
the petitioner died in 1950 and the RS record of rights reflects the date on the date of possession, that is the date of vesting, that is either 15th April 1955 or 14th April 1956. From that possession, RS record of rights, not prior to that. And here the record of rights is showing that Bharat Samrat Pokkhe 24 Pargana. So it is CS. And Malad, kindly see the stamp. 51A of the Land Reforms Act. And Malad, in my affidavit in opposition, I have taken the point that this does not match. And we have paid the award compensation money to the recorded owners, which is available from the BLLR office. I have annexed in my affidavit in opposition. Those are the different persons. In the RS record of rights, the interest of the superior interest, either Postimbango Sarkar or something like Mr. Kishore Kumar Datta, তার আন্ডারে তা অন্য কেউ আসতে পারে, not the ভারত সম্রাটের পক্ষে.
All right.
And I have taken that point, and that point has been considered. And secondly, my lord, in my affidavit in opposition, that is volume 2. Volume 2, my lord, I have annexed the record of rights. If your lord will kindly come, that is page 106. According to our records, the government record, these are the owners of those plots. 106. And notice has been served upon them, and they are the awardee, and compensation money have been paid to them. And another thing, my lord, if your lordship kindly come, my lord, the page 47 of the writ petition, That is volume 1. Volume 1, page 47.
Yes.
Prafullo Kumari Datta died on 7th February 1950. And my lord, kindly see the heirship. Now, Supriya Datta is the only petitioner. How he became the owners from Supriya Datta? There is nothing, not a single averment. How Supriya became the sole owners of those lands? And my lord, learned advocate made the detailed submission relating to the notice 3.1 as well as the 4.1. And in my affidavit in opposition,
No, but Supriya's Supriya's name is there.
their name is there.
Page
She
40.
made one of the errors. She cannot claim the sole owners.
Even one of the heirs can come and challenge the proceedings if they are otherwise entitled.
If otherwise entitled.
If otherwise entitled.
If otherwise. But he has no, there is no averment that I am co-sharer of that property. I am
That is a minor point.
minor. But the thing is that, my lord, the Supriya, my lord, the Prafullo Kumari died in 1950.
Yes.
So the record of rights which have been relied upon, Bharat Samrat Pokke, cannot be said the correct true record of rights, and no other documents relating to the title has been submitted for maintaining the writ petition. And our official record, the record of rights belong to RS record of rights belong to the other persons who have been given the all requisite formalities, notice, taking possession, and awarded money have been awarded to them. And when the other question of law, my lord, has already submitted by the learned advocate general, my lord, I need not elaborate for the same.
Yes.
I will not answer Mr. Mahato's contention first. Lord, the reading of the record of rights.
Yes.
Lord, probably Mr. Mahato has been overlooking the fact. Lord, kindly turns to page 50, Lord. Lord, sees, Lord, in the top bracket of page 50. Lord, when I'm reading, Lord, in the middle portion after Toji number 13 below that.
Yes.
Revenue survey number. Lord, this indicates this is RS record. Revenue service is always RS. So that's why it contains revenue survey number. Whether Mr. Mahato has been contending, my lord, this is CS survey.
Bharat Samrat?
Yes. Now, my lord, after my lord knows, my lord, when Estate Acquisition Act came, my lord, when the Jamindar's lands were, my lord, vested with the government, those who were in occupation of the land, my lord, their names were, my lord, recorded as Stitiban Rai. My lord, Prafullo Kumari Datta being one of the occupiers under those Jamindars, my lord, Prafullo Kumari Datta and two other name, my lord, will find the husband, Nibaran Chandra Datta. My lord, they were recorded as the Stitiban Rai. My lord, maybe my lord, Prafullo Chandra Datta died, my lord, we have not intimated to the authority that Prafullo Chandra Kumari died, but that doesn't mean, my lord, the law of, my lord, estate acquisition of vesting, my lord, gives ownership, my lord, doesn't change. So, my lord, RS survey also, my lord, while recording the same, my lord, carried forward, my lord, what was there in the CS record. Now, my lord, apropos this, my lord, if Mr. Mahato's contention is also to be taken on the face value, my lord, this is CS record.
Then also, my lord, kindly visualizes, my lord, the letter issued by the KMD authority in 96.
No, he does not say that. He says there is a mismatch for that reason.
This is a mismatch. I am
Mismatch because it's under
genuinity. I am asking
under section
questioning the
50
genuinity.
under section 51A of the WBLR Act
Yes.
with again Bharat Samrat.
Yes.
My lord, that's why
These are the discrepancies. That's why he said it's a
Bharat Samrat,
mismatch.
because after State Acquisition Act came, my lord, 54, 53, sorry, 53. But thereafter, my lord, 55, if it starts, my lord, after Land Reforms Act came in, my lord, there, my lord, it will be recorded under 51A, my lord, that vesting part and my lord, Sthitiban Rai. So that's why, my lord, Revenue Survey was prepared like this. Now, my lord, what I intended to say by relying on the 96
But
letter.
then there was an elected Bharat Samrat. That is what he is trying to say.
Now,
maybe Bharat Samrat still,
yes.
but elected.
So, my lord, Bharat Samrat being the superior landlord, I being the Sthitiban Rai being declared.
Yes.
Now, my lord, what I intended to say by referring to 1996 letter was, my lord, even the KMDA was in possession of records, cadastral survey. From there, they refer to me as the legitimate owner in 96, because they are looking in the cadastral survey records.
That was which page?
My lord, kindly
Where
take
they
up the
admitted?
volume 1.
Yes.
Yes.
This page 67.
Page 67. And my lord, the other one is page 69.
But that was on your application.
No, my lord, initially 96 was their letter. First letter came from them. So they were having government records where, my lord, Prafullo Kumari Datta was the recorded owner. They were writing addressing Prafullo Kumari Datta. My lord, they are not aware whether Prafullo Kumari is dead or not. From the record of rights, my lord, they are finding Prafullo Kumari Datta to be the owner. And my lord, writing letters. Now, my lord, with this, my lord, the record of rights, my lord, therefore, that authority was also having the same record of rights as I am having in my hand. Now, my lord, state in rebuttal, and my lord, the KMDA in rebuttal, my lord, who supports the state contention, state, most incidentally, state KMDA, my lord, has never denied these letters. It was never denied by them. What was denied was, my lord, that those replies from the RTI authorities, but these letters were directly issued from the office of the KMD. These letters are never denied. Now, my lord, KMDA in supporting condition.
But this was after the 44-2A.
This 96? No, my lord, 44-2A happened in 2005. Final adjudication of 44-2A. If my lord looks in the last order which was recorded.
Just give us the page where we'll find the date. Need not place the entire thing.
My lord will find page 157 at the top, case number 1 of 2005. So that was the case number recorded. So post this happened.
All right.
Now, my lord, next contention, my lord, of Mr. Mahato is, my lord, as there is a dispute, my lord, they have paid the recorded as per their BLRO, my lord, records. My lord, they have paid those persons who feel they are entitled to the compensation.
No dispute. They say their names appeared in their record.
Apparent in their record.
Yes.
And one of the records which they rely, the authorities in under 42, 44.2 has said that is wrong.
Yes.
That is absolutely wrong. And my lord, that record which they have relied, my lord will find just for my lord's indication.
No, but Mr. Dotto and Mr. Mahato say that those were done, 44-2A came later. So retrospectively, there at that point of time, those were the recorded persons, and compensation was given. They took. So therefore, retrospectively, a subsequent correction cannot retrospectively vitiate the acquisition process.
No, my
That
record
is
of
what is their contention.
my record of rights, if at page 50, my lord looks into, my lord, the date is though not clear, very clear, but it is prior to my lord
আমার সব ইস্যু হয়েছে এই তারিখে
83, 1983. Kindly takes the page 54 once. 83. Volume 1, my lord.
Yes.
My lord will find revenue officer at the bottom, my lord, 83. 83. So, my lord, these were existing, my lord, when 73 was there. And, my lord, the record of rights which they rely upon, my lord, if my lord kindly has a look at it.
When was the notification issued? That notice issued? The notification under section 4 and all?
But at 74, October 1974. To be precise, 17th October 1970. Gazette publication under section 4.
All right.
And, my lord, they rely upon the document at page 106. So, my lord will find that is obtained by them in the year 2000. At the bottom of that page, my lord will find that. So, my lord, I rely upon a certified copy given by a revenue officer of 83. They try to dispute my document by a document of 2000 issued by another authority or the same authenticated, my lord, by the block land and land reforms officer. My lord will find 106 bottom 2000. So, my lord, they are bringing in document, my lord, of subsequent event. So, my lord, Mr. Dotto's contention, Advocate General's condition that in 2005 court would not rely. My lord, same principle would apply to this also. Because they are relying on a document obtained by the BLRO in 2000. So that's also a post document obtained by them. And I am relying on a document which is though post to the publication, gazette publication. But
very difficult for a writ court to decide, Mr. Chatterjee.
No, I am on two things.
Very difficult. Evidence was required in this matter. We feel handicapped actually.
No.
If it was a first appeal, then we could have very well adjudicated because the evidence would be before us.
I understand.
We could draw adverse inference also if no expert was sought, and those things could follow. But before a writ court, we decide on affidavits. That's a difficult.
Two things. I understand what is falling from, my lord. These documents.
At the end of the day, wherever we go, we come to a blind alley that evidence on detailed facts are required.
My lord, if a question of law is drawn, my lord, for a writ court to decide, my lord, we need not go into the facts at all. My lord, if the court has held correctly that writ court is not there to decide on title, then, my lord, this RS record of rights which we have produced, only because we are producing RS record of rights, my lord, is the court, my lord.
That's only locus standi, not
locus standi.
Yes,
absolutely. So, my lord, my case
that writ court can hold prima facie whether you have locus standi or not.
So, my lord, today with this document, when there is no, my lord, discrepancy, my lord, today at least I have a prima facie locus to come before this court. I put it in this way. My lord, if
prima facie locus at the final hearing of the writ petition, that concept is unknown. You have to decide your locus at the time of, at least before the decision of the final adjudication of the writ petition, Mr. Chatterjee.
Yes. So
you may say prima facie title.
Prima facie, yes. Prima facie title.
Very well. But that remains arguable at the end of the day. Therefore, I mean, locus standi, if that remains arguable, you don't know.
Locus, my lord, I say, my lord, I have come before this court saying that my predecessors were the owners. I suddenly found
that is why we are. That is what we are saying, Mr. Chatterjee. It boils down to wherever we go, whichever route we explore, leads to a blind alley where it ends with complex questions of fact. which are required to
No,
be
my lord,
decided.
to be more impactful, my lord, 2 times, my lord, there were 2 addition of parties. My lord, those applications were, my lord, dismissed on the ground, my lord, that no, they were affecting my title. They're saying that they were the owners of the land, not me.
Where in this writ petition?
In this writ petition.
What happened to those?
My lord, those applications were disposed of or dismissed, my lord, by saying that prima facie I have produced document, and since this is a question where only relates to whether at all there was an acquisition or not. If there is an acquisition, I'm out of the court. Even if I am an owner, my lord, even if I am an owner, my lord, today, then I'm out of the court.
No, compensation you are interested.
Compensation, my lord, even to that, my lord, if somebody comes.
But you are
and-
challenging the acquisition proceeding itself.
Yes. So, my lord, my first thrust.
Yes.
My first thrust was if there is no acquisition, my lord, then everything goes. And if there is an acquisition, yes, I have a right of compensation. I will pursue in civil court. I will dislodge the other claimants.
Very.
So, my lord, to this extent, my lord, the first, by holding the first part, my lord, court throws me out saying that you cannot agitate these points. Now, my lord, if the first part goes, my lord, is in my favor, rather, my lord, I have a right to come before the court. Now, my lord, with this document, then, my lord, the only question left is, my lord, whether there was an acquisition or not. Now, my lord, to show, my lord, there was no acquisition, my lord, I have spelled out that there was no section. This was my argument, rather, my lord. No pleading as such to that in apropos. My lord, I was argued that there is no issuance of or compliance of section 3. Rather, may I put it in that way? Compliance of section 3 under the Land Acquisition Act. Now, my lord, what happens, my lord, during the final argument stage, my lord, the state produces these 2 pieces of papers before the court by putting it by way of a supplementary affidavit. We are only stating we have complied with section 3. Otherwise, my lord, in the affidavits which were filed previously, my lord, there was no, my lord,
But you must have been given a copy of the supplementary affidavit.
In the read, no point was taken.
I mean, both
Argument it
You
was
must have
taken.
got a copy of the supplementary.
Yes, yes. My lord, I argued on that. After having that copy, my lord, I argued
No, no,
only because I have no chance to deal it in writing. My lord, that chance was not given to us because when it was handed over, my lord, court said you argue orally. So, my lord, I argued on oral. Now, my lord, when I was arguing, my lord, I took 2 points. My lord, one, Mr. Rai has already, my lord, indicated. My lord, that there was no service because in the form, my lord, there is no indication at least to whom. My lord, it may not be directed to me. My lord, they are holding some record of rights. It may be directed to X. So, my lord, there is no direction to X to be served.
All right.
This is one. Second is, my lord, there was no signature. Now, my lord, learned single judge, my lord, has obviated that part by saying there was an attestation done. My lord, this attestation, my lord, my learned single friend, senior friend, my lord, on the other side, is always referring to, my lord, the second page. My lord, the attestation was not at the second page, but it was referring to the first page. My lord, first page, my lord, will find in the bottom in 2014, South 24 Pargana Alipur, my lord, Collectorate Office has attested. My lord, as far as, my lord, I understand, when there is an attestation, my lord, it is the attestation of the original. So, my lord, I presume in the original there is no signature because he is attesting a document without a signature. So, at least this presumption is with me, my lord. In original also there is no signature in the first page.
The first page there is no signature. You saw
No
that.
signature.
Yes.
So, whatever signature is there in the second page.
Yes.
Now, my lord, if my lord kindly looks into the first page once, my lord.
Which page?
My lord, that page, internal page, sir, page 266 of volume 3, my lord. My lord has got that, no?
Yes.
My lord will find after the schedule.
You quickly complete, Mr. Chatterjee, because we'll close arguments on this then.
Yes, yes. You know, give me 10
Because
minutes.
after 2 years, you don't have 10 minutes then we'll have to keep it pending. Anyway, continue.
My lord, after schedule, my lord will find there is a stroke cutout of collector. It was produced by them.
Page 260?
My lord, 6, my lord, internal page 7, my lord, the section 3 form order which was relied upon. My lord, after the supplementary affidavit.
No, this is something else.
my lord, volume 3, my lord, has got, my lord,
Yes, 266 is something else.
269, sorry, my lord, 269, the supplementary affidavit.
No. Yes, supplementary evidence.
My lord, supplementary affidavit ends at internal page 6.
Oh, that
and the next
internal page 7 of that.
Yes, yes.
Yes, yes. Yes. Got it. What is the context?
Find bottom, my lord, there is a striking of collector.
Yes.
So, my lord, one point was there, my lord, this was either issued by the additional district magistrate there. Now, my lord, referring to, my lord, the provision, my lord, additional district magistrate had no authority. It was the land acquisition collector. And, my lord, if my lord looks at this order also, my lord, they refer to the amended provision which was inserted in 1965 ordinance. So therefore, if it is an act, not post ordinance of 1965, then the ordinance is clear that nobody save and except the land acquisition officer will issue this order.
Yes.
So, my lord, if that be so, my lord, even arguably, my lord, taking that there was, though not admitting, my lord, there was a section 3. My lord, it was divorced the provision of law.
Very good.
This is one aspect. Second, my lord,
Yes.
my lord, if my lord takes up the Land Acquisition Act,
We'll continue on the next day.
the next day, next Wednesday,
Next Wednesday.
my lord, Mr. Rai and my lord, both of us are out of town. Maybe on the reopening date, second.
Heard in part, full stop, next para. Learned counsel for the appellant, comma, who is in rejoinder arguments, comma, submits that he is in some difficulty on next Wednesday, comma, on which days these matters are taken up for hearing. Full stop. Accordingly, let the matter stand adjourned and be listed next on January 7, 2025, under the same heading. 2026. Thank you. So we'll continue on then. Yes. এই যে বইগুলো এগুলো রেখো। এটা নোটস চল Yes.
My lord, with all humility, my lord.
Yes.
My lord, that the property, my lord, that the on which I have spent, my lord, a leased property, my lord, and my lord, that the I am a successful bid.
What are you mentioning now?
My lord, I'm mentioning, my lord, that because that they are going to lease out my
For what?
mentioning for the
Inclusion of what?
application. No, my lord, it is already, my lord, there. And my lord, that it was item number 42 when 41 was taken up. Thereafter, my lord, it is downtrodden journey it has. My lord, that it is now today's 163. My lord, I think, my lord, that it's a most fit case. Yeah, it will take only 2 minutes because that the learned, my lord, that the trial court has not passed any order on which ground I have been, when I have paid rupees.
So it has
2
become
crores.
163 because we take up civil division, civil application alternatively. Applications relating to civil matters 1 week.
We have already
The next
served
week
the
we'll
other
pick
side,
up-
my lord, that the
Next week we'll be taking up application regarding writ first.
my lord, that next week, my lord, any day.
So
my
it will
lord,
appear in the list as it
but
is.
my lord, it will appear, my lord. But for abundant precaution, at least we can inform because that
mentioned.
2 crores 20 lakh
No, no, sir.
rupees.
Because it will appear. It will appear in the list. It will appear in the list. Alternatively,
It
we.
will appear in the list, but it must have to be taken. I will not disturb your lordship, my lord. Only 2 minutes time will be required, my lord.
Whenever it comes up, yes.
My lord, I'm grateful, my lord. Once, my lord, it should be given.
No, we are not adding any matters before the.
I'm grateful.
Injunction application.
We are not adding any matters. Yes.
One application matter has been released.
We're not adding any matters.
Matter has been released by the for judgment of before appropriate division bench.
After the vacation, we'll take up matters.
Only one.
Yes, matter has been-
Prior to vacation, my lord, if item number 137 is taken up.
What is the urgency?
Urgency is, my lord, my business, my lord, though I am running my restaurant, but my lord, my legal
upgrade, Mr. Chatterjee.
My lord, this is the Xmas time when, my lord, my stocks of liquors are there.
Understood. We cannot upgrade matters. No. Yes.
My lord, I'm praying for correction of order detail.
Yes.
My lord, may I be permitted to mention one matter for extension of interim order?
Yes. To be mentioned for release.
Lordship, I permitted to mention one matter, Your Honor. Lordship passed an order of injunction on the trial court's order.
What are you mentioning now for?
Application, Your Honor.
Application after vacation. Come back after vacation. Yes.
No, the trial court is proceeding with the matter on the ground of
hide the pendency of this matter before this could be.
even though it was
Sorry, no.
My lord, may I have your kind leave to mention a matter for inclusion, my lord?
We are saying no to everybody. Why don't you?
Substitution application, my lord.
No.
My lord, item number, my lord, 25 to 37, my lord.
Yes.
In this matter, my lord, Mr. Susuman Singh is appearing for the appellant, my lord. My lord, out of state.
When it is called on, please ask somebody to mention. Call on the list.
Number 1 to 40.
In this bunch of matters, my lord, we mentioned, my lord, because
Yes.
the similar matter arising out of the same land acquisition process, my lord, a judgment was delivered by your lordship. We asked for the same benefit, my lord, because same land, my lord, same plot number. And
What
same,
was the nature of the judgment passed by us?
your lordship fixed, my lord, the quantum of compensation at 5,52,000. But so far as the interest part, my lordship remanded the matter back for deciding what is the period of, my lord, taking over possession. So that
From the same land acquisition proceeding.
same land acquisition proceeding, my lord. Now they took time, my lord. I have handed over the copy of the last day.
You have handed over
SLP that has been dismissed. SLP has been dismissed. They took time because not the SLP was pending.
No, SLP order you have handed over on the last.
Yes. Today I'm handing over. Now
So we'll reserve judgment. We'll just check up the matter and pass.
I have to point out the matters because appeal and counter appeal. Because unless not the cross appeal is there, my lord, state has preferred appeal. Appellant has also preferred appeal for further enhancement.
1 to 4, my lord.
I have prepared a chart. I have prepared a chart. May I just not point out not the matters?
That will be very helpful. Yes.
Item 1 is to be taken with state appeal. Item number 7. I have
Right.
mentioned 1 to be with 7, 2 with 5.
Why this?
Because state has also preferred an appeal. We have also preferred. So two are to be taken up together.
Very well.
Like the other matter, your lordship decided.
Right.
Appeal by
So 1 and 7 both are regarding Shubhadeep Bose.
Shubhadeep Bose.
The rest also similar.
Not all, 2 with 5, 3 with 10, 4 with 12. These are there's no problem.
2 with 5, then why have you mentioned 5 again?
No, your lordship will find item 2, state's appeal is item number 5, I have mentioned. In the second column.
Oh, item number.
State's appeal, item number 5. In bold, I have mentioned.
Achha.
So corresponding state's appeal I have mentioned.
Up to 4 we have understood.
No
what about 5?
5 is with item number 2. Then 6.
5 is
5 with I have mentioned.
So these item numbers are item numbers in this list.
In this list, today's list, serial number.
State's appeal item 5
is today's list, my lord. Today's list.
Item 5 of today's list.
Today's list.
Achha, very
First column is item number of today's list. Then the case number.
Well, yes.
Now, not serial number
What
5.
about serial number 5 of you? This
5 is not today's list. 5 is not to be taken up with item number 2. I have mentioned.
No. Your serial number 5, FAT 277.
277 is serial number 5. Kindly come back to serial number 2, my lord. FAT 267. It is Subarna Singora.
Suppose in your list, item number is 1.
My lord.
You say that has to be taken up with state's appeal item number 7. Item number 7 of this list.
Today's list.
Today's list or this list?
Same, my lord. Because I have prepared as per the
Oh, achha.
It is the same.
So 5 is covered.
5 is
6
covered.
date. What about this?
This has to go out of list, not because Savitri Banerjee has expired, madam.
Very well. What about the others? 9 also same.
7 is not to be taken up.
9 we can allow the substitution right now.
No, applications are possibly not on record.
9?
It has not. 9 also not substitution is pending. I don't know whether it's listed or not. Your lordship can allow.
So this can go out.
These two will go out.
8, 9.
No.
9,
6 and 9.
6 and 9.
6 and 9 will go out.
Very well.
I mean 8 and 13, my lord, we have filed cross appeals because it was not there. We have filed. We shall hand over the number. Kindly adjourn these matters 8 and 13 because unless the cross appeal is filed, the enhancement cannot be given.
So we'll direct
these two will
all of these matters to appear together on next Monday. Hand over the copy numbers of the cross objection in the meantime. So you can pass a composite order. We'll direct the matter 6 and 9 will direct to go out of the list immediately. And regarding cross objection to be filed, that is 8
and
13.
We have filed today. We'll get the number.
So give the numbers today. All the rest of the matters will appear together on Monday. And what about 14?
14, my lord, it is to be, I mentioned, to be listed with, my lord, state's appeal FAT 265, which is not appearing today. So one.
Very well.
So it shall appear with
all action order হবে. Learned counsel appearing for the land losers submits that the present appeals arise out of a land acquisition proceeding in respect of which other matters have already been adjudicated finally by this court. Which of next para? Learned counsel hands over a server copy of an order passed by the Honorable Supreme Court whereby, vide order dated December 15, 2025, the connected specially petitions were dismissed. Fullstop next para. Accordingly, it is submitted that the present appeals may also be decided in consonance with the judgments passed in such other matters. Fullstop next para. A copy of the judgment passed in the said other two appeals is also handed over in court today. Fullstop next para. However, insofar as FAT number 271 of 2020 and FAT number 276 of 2020, in view of the demise of some of the parties, the matters are directed to go out of the list. Full stop. All the matters may be listed together on December 22, 2025 under the same heading, along with the cross objection. You have already filed.
Yes, my lord.
Cross objections filed in respect of FAT 273 of 2020 and FA number 200 of 2025, along with FAT 265 of 2020. The
handing over the number.
Cross objection numbers. Thank you. ওই দুটো ক্রস অবজেকশন আসবে আর একটা এফএটি বললাম যেটা লাস্টের লিস্ট সেটা এই লিস্টগুলো এর সঙ্গে রেখে দেবেন।
Appear on behalf of the
Yes, what is the matter?
petitioner, my lord. Page 16, paragraph 75. My lord has recorded matrimonial suit number 1055 of 2015. Paragraph 75.
Yes, matrimonial suit number
1055 of 2015. It should be 101 of 2015.
That is the only thing. Learned counsel appearing for the appellant points out that in the judgment dated December 11, 2025, passed in FA 160 of 2022, in paragraph number 17 thereof, The number of the matrimonial suit has erroneously been recorded as 1055 instead of 101.
Instead
Instead of 101. Full stop. Accordingly, let paragraph number let the number of the matrimonial suit in paragraph number 75 of the judgment dated December 11, 2025 be read as matrimonial suit number 101 of 2025. Full stop.
2015.
Sorry, 2015. Full stop. Next para. Let this order be deemed to be incorporated in the order judgment dated December 11, 2025. You also apply for a copy of this order so that you can place it along with it.
Number 16.
Number 16, I'm for the appearance.
Non-prosecution?
Yes, but matter is settled out of court, it is instruction I'm filing.
Learned counsel for the appellant submits that the matter has been settled out of court, and as such, the appellants do not want to proceed any further with the appeal. Full stop. A written instruction in that regard filed today in court be kept on record. Full stop. Next para. Accordingly, SA 58 of 2023 is dismissed for non-prosecution without any order as to costs. Full stop. Interim orders, if any, stand vacant.
Obliged.
Thank you.
17, my lord, an application has been made in a disposed of appeal, my lord. My lord, initially a suit was filed for building rebuilding.
Why is it appearing is to be mentioned? Should appear as an application. Directly to appear as an application. It will be heard in due course.
There's only one thing, Your Lordship. SLP has been preferred against this order. I can give him the number if he wants.
Give him the number and we'll just direct it to appear in the list.
Yes.
Whenever it is called, if it is called on prior to the disposal of the SLP, just point out, please.
Let it be on next week then. 22nd.
Yes.
My Lord keeps it after the vacation just in case.
Very well, very well. Learned counsel, learned senior counsel, you are for the appellants. Appellants have filed the application. Learned counsel for the appellants points out that the present application has been filed in connection with the disposal of appeal. Full stop. Learned counsel appearing for the respondents points out that special leave petition has been filed against the judgment disposing of the appeal, which is now pending. Full stop. Let accordingly, let CAN 3 of 2025 be listed in the monthly list of January 2026.
Only one thing. Just in case the SLP is dismissed, then I must have an opportunity to file an opposition to this.
But let it come back on it thereafter.
Should you grant you that opportunity right now?
No, I was just if it's kept open because.
No, we have not even passed an order on the
very well.
We have just directed the application to be listed.
Great.
Hey, you can do this, you have practiced for quite long.
Execution application second.
No, not that. If you see in the meantime SLP is dismissed, then you can prepare your opposition and give them an advance copy. So that we can take it on board on the next day and we can grant it. Thank
Item number 18.
you. Application. None appears for the parties at the time of call. Let the matter be listed in the monthly list of January 2026. Yes.
Item number 19.
I am for the applicant.
Yes. What is
Service has been complete. I am filing the certificate of service.
You have checked up. Filing has the service has been complete. What is the matter?
It is a restoration application for dismissal of the said.
Condonation application is also there.
Yes, my lord.
What is the delay?
My lord, to 309.
Explanation. What is the explanation?
The commandant advocate passed away and brief was not available.
Despite service, none appears on behalf of the respondents. We'll stop. Next para. On the prayer of learned counsel for the appellant, leave is granted to the appellant to file the affidavit of service in that regard during the course of the day. Full stop. We are apprised by learned counsel that good service has been effected. Full stop. Next para. Accordingly, we take up the matter for hearing. Full stop. Next para. Upon perusal of the grounds shown in the applications, we find that the erstwhile learned advocate appearing for the appellant at the relevant juncture had met his demise, upon which some time was taken to trace out the brief of the case from his chambers. Full stop, next para. Thus, we find that the present application has been filed bona fide and there was sufficient cause for the delay in preferring the appeal. Full stop. Accordingly, Can 2 of 2025 is allowed, thereby condoning the delay in preferring Can 1 of 2025. Full stop. Can 1 of 2025 is also allowed, thereby recalling the order dated December 13, 2022, whereby SAT 267 but you had not put in deficit code is for
Yes,
that
my lord.
reason.
You have already filed it, my lord.
How could you file if it was dismissed?
No, my lord, by the order of the Honorable Court, my lord, later on.
When?
That in Can 3 order, my lord.
Ach. Recalling the order dated December 13, 2025, whereby SAT 267 of 2016 had been dismissed on the failure due to the failure of the appellant to put in deficit court fees in time. Push up next para. Since it is pointed out from the records that subsequently, pursuant to the order of this court, deficit court fees have been put in, we accept the said deficit court fees upon condonation of delay in depositing the same. Push up next para. Accordingly, SAT 267 of 2016 is restored to its original file and number. It was never admitted. Let the appeal be listed under the heading Order 41 Rule 11 in the monthly list of January 2026.
Item number 20.
You're appealing?
Yes.
Move. What is the matter?
Actually, substitution application, restoration, and two section 5 order. Actually,
Have you served? This is the first time. The appellants shall serve copies of the applications on the respondents, indicating that the matter shall be listed under the same heading in the monthly list of. Then this is second appeal. So then these applications have to go before the land single judge. The appellant.
Also, order 41 actually not complete.
Substitution you are saying?
Yes.
Before order 41 stage, you have to get to it. And there are section 5 applications and all these things. The appellants shall serve copies of the applications on the respondents and file affidavit of service on the returnable date. First of liberty is given to the appellants to mention the matter before the appropriate learned single judge having determination, upon service having been effected, for inclusion in the list before such bench. Get it allowed and then come back with order for
Item number 21.
Yes.
Your Lordship, I appear on behalf of the appellants. Your Lordship, there's a predicament, it's a change brief, Your Lordship. 2 cans have been filed, one for restoration and one for substitution. The erstwhile advocate and court have served them, but the file does not provide the track report of all the defendants. So a fresh service is required to be made on all.
Learned counsel for the appellants fairly submits that since he is appearing on change, you will be giving your name only.
Yes, sir.
He is appearing on change, and learned counsel is not apprised of whether proper service was effected on all the respondents, we direct the appellants to effect service of the of all the applications on the respondents, indicating that the matter shall be listed under the same heading in the monthly list of January 2026, when an affidavit of service shall be filed by the appellant.
Your pleasure.
This was for restoration of at the order for 20, dismissal at the order.
Dismissal.
Number 22.
None appears to move the application. Push up. Accordingly, let the matter stand adjourned and be listed next in the monthly list of January 2026.
Number 23.
এগুলো কি মেনশন করে এসছে নাকি ডিপার্টমেন্ট সব মেনশন করে? Is for the parties at the time of call, let the matter be listed in the monthly list of January 2026.
Item number 23. 24.
24. For the respondent, for the appellant, so this matter was fixed by your lordship, my lord, in hearing. Suddenly it has come back in application head, my lord. Lordship, my lord, on 25th of August 25, my lord, specifically directed, kindly sees that order once, my lord. They are filing applications for money and not getting the appeal delayed.
No,
lordship,
not that.
kindly allow me to point out, kindly see paragraph 6. The lordship said that they cannot do this. Matter shall appear.
Which date?
25th of August 25, paragraph 6. Then it appeared for hearing.
But it was appearing in the list as per hearing also.
It has come back and they have filed one application for permanent alimony, CAN 3, which they have served.
CAN 4.
CAN 4 is permanent alimony.
Another application has been filed and mentioned.
No, we have not mentioned. It was listed.
Then why? CAN 4.
It was
Application under the heading application due to the laches of the officers of this court. Full let the matter be restored to its original position in the hearing list.
My lord, item number 25. 25 to 37, my lord.
Yes.
Sushaban Sengupta is appearing in this case. He is out of station, my lord. I am praying for after vacation, my lord.
On the prayer of the appellant, let the matters be listed in the monthly list of January 2026.
Grateful, my lord.
So Mukherjee, you are for the other side.
That 25 to 37. 37, bole diyechi.
Nin. Next. After.
Only substitution
After.
application.
We cannot add matters and you take. Not. Somebody ought to have been there. Next, call on the next. None appears for the parties at the time of call. Full stop. We find that on November 11, 2025, an adjournment was sought on behalf of the appellant, and when we insisted that the matter be argued, since the same was appearing fairly up in the list, learned counsel seeking adjournment refused to move the matter, for which the appeal was dismissed for non-prosecution. Full stop. Even today, none appears to move the recalling application. Why are you so late? Yes, what is the matter?
Sorry.
Recall application will allow subject to, this is under order for 10 rule 11.
Yes, yes.
You move the
Immediately I shall move.
appeal immediately. There is no caveat.
No, no caveat. I lost in both the court below.
Very. Can one of 2020, in view of sufficient cause having been shown for the failure of the appellant to move the matter on November 11, 2025, can one of 2025 is allowed, thereby recalling the order dated November 11, 2025 and restoring SAT 254 of 2022 to its original file number. The matter is now taken up for hearing under Order of Rule 11 of the Code of Civil Procedure. Ager portion ta bad jabe. Yes, move the matter.
My lord, appellant or my lord, trustees as well as my lord receiver. They got a power to evict the my lord illegal trespasser in the my lord estate of including the Sebayat, other Sebayat, because there are other Sebayats who are the defendant in the suit. They have occupied certain portion of the my lord, that my lord trust property.
So how did you acquire? You acquired from the same Orponnama?
Same Orponnama.
You and them?
Yes.
In that right was given to you to evict the others?
No, that right has given my lord in a subsequent suit. There was a mismanagement. There, my lord, I filed a suit. In that suit, my lord, it was decreed if my lord Sebayat.
Was a suit under?
Under my lord, for for the management, proper management of the suit, my lord.
This
Under
Trusts Act or Trusts Act?
I think it's not a public trust.
92?
92.
Section 92?
92.
So in that suit, a decree was passed?
Decree passed.
Giving you the right, you have annexed that, must have annexed
that. That is my lord annexed. That is my lord exhibited. That is exhibited.
So where is that? We want to, that is the premise of your argument.
I think it's LCR has come, my lord.
Why LCR? You don't have any connected application?
No, still correct.
So you should have a copy of that at least.
And one.
Unless you look into that, how do you decide?
Yes, yes.
That is the only thing which you have to look at.
No, here the question is whether my lord, both the court below says that I cannot file a suit against a Sebayat or cannot be termed him as a trespasser.
We want to look at the Orponnama,
Yes.
that
Yes.
order of the court, as well as the Orponnama, if you have it.
Give me a few days, man. Yes. Kindly excuse me, I have just only one copy, Madam.
Defendant's father was also given a right in this Solenama.
Yes.
So how can you evict his son?
No, they have not exceeded that Solenama. They are now occupying a portion which is not mentioned in the Solenama. That is the property of the deity.
But that is a question of fact. Where is the substantial question of law? Both courts
Question is
came
law-
to finding that you failed to prove your case.
Question of law only that
Unpartitioned property.
if Malad,
Unpartitioned property, trust property
cannot be Malad. Here Malad court has committed error, both the court below.
Why?
Says that it is deity, property belongs
How
to the
can you
deity.
get an eviction? Because everybody has right over every portion.
It is being a Malad Shebayat as well as Malad receiver.
They are also Shebayites.
No, they have exceeded their Malad. Suppose there's a Solenama. Initially in this Malad
They have
Orpunnama.
exceeded their what?
In the Orpunnama, there is no provision for Mala right to reside of the Shevites. Thereafter, subsequently, a suit filed. In that suit filed was compromise decree was passed, in which some arrangement was met. They have exceeded that arrangement, and they have also admitted in the appeal. They have also made some illegal construction, as also occupied some portion after removing the tenant. They are occupying. That property, that room belongs to the Mala deity.
Where is the Solenama?
Yes.
What? This is an order.
Yes.
Liberty to sue. Liberty to sue does not mean that.
No, I'm not on that. But
you have a right.
Even I have a right to protect the property.
Can file any suit, but that does not confer on you a right.
Malat,
you are a Shebite, they are also
deity is a
Shebite.
Malat. Your lordship knows that the deity is a Malat juristic person and minor. It is represented by the Sheba.
Precisely. All of you are Shebites. How can
Shebite. Now, if Malat, that is the question, Malat, I'll satisfy your lordship. If a Shebite acts anything which is prejudicial to the interest of the deity,
what is
then that they have Malat occupied, Malat certain portion. They have also Malat made illegal construction.
You are also seeking their eviction. What is your right to seek eviction against them? You are on a parallel footing. Your right and their right are same regarding residence.
Residence, no. Their right, Malat, I am not disturbing their residence, which has been Malat.
Seeking their eviction.
From other property where it is not Malat mentioned in the Solenama.
Solenama, you cannot enter into a Solenama by regarding distribution of trust property. You cannot rely on that Solenama. That Solenama is the premise of your eviction suit.
Even that one, in that case, nobody can stay in the Malatary. I am not saying there.
Your suit, you have to stand on your own case as held by the courts below. You, one of the Shebites, cannot get an eviction against the other. Whatever Solenama was entered into between yourselves. What was the Solenama? That you will reside in specific portions.
Yes.
You could not do that. That Solenama is bad in there.
Yes. Well, that is bad, but
then you cannot get an eviction from a particular portion. Everybody has right to reside over. If you have a right, they have a right.
I am not residing there.
You are seeking eviction decree. That
eviction
means
on behalf of the Mala deity.
You first go out, then they'll leave the property.
On behalf of the deity, my lord, I am only doing the Seva Karma, my lord. That is, my lord.
Deity acts through all the Shebais, not through you alone. You cannot get an eviction of the other Shebais.
My lord, Seva, my lord, kindly consider, my lord, what is my lord plaint.
You have said what is in your plaint. You rely on a Solenama decree where the Shebaites agreed to reside in specific portions of the property. And the premise of your now the premise of the present suit is that they have exceeded their portion.
After evicting some tenants.
Whatever.
Yes.
They have exceeded their portions.
Yes.
They don't have any portion. You also don't have any specific portion. Everybody has
Specific
right over.
portion.
How can you get eviction against them regarding any portion? There is no demarcation, no question.
Yes, demarcation is there, my lord. Demarcation
cannot be a trust. The DT's property cannot be divided.
Divided. My lord,
cannot divide it.
My lord,
That
that
Solenama is bad.
That is
that Solenama is bad in law.
Nobody has challenged it, my lord. That is, my lord, one.
It's a nullity. You cannot.
My lord, only my lord, humble submission that question. Only my lord, law involved whether my lord is Shevat, my lord, if Shevat acts anything prejudicial to the interest of the deity.
You are acting prejudicial to the interest of the deity because you are trying to evict the other Shevites.
No, my lord, they are. Well, I am. Well,
you are espousing your own cause, not the deity's cause, because deity's cause is subserved by all.
Kindly cease, my lord, my prayer in the plaint. Even they have, my lord, accepted. They have, my lord, occupied that
prayer in the plaint.
Yes.
কিছু সব ভুলে যাবো পার্টিশন করছে সেবাই ডিটি প্রপার্টি the present challenge has been preferred. The present second appeal has been preferred against the judgment of affirmance, whereby both the courts below dismissed the suit filed by the plaintiff stroke appellant, comma, inter alia, for declaration that the defendant is a trespasser and unauthorized occupant regarding a portion of the subject property and seeking eviction of such purported trespasser from the said portion. For the next para, admittedly, comma, the subject property belongs to a deity by virtue of an Orponnama. For sub next para, both the plaintiff, comma, acting in the name of the deity, both the plaintiffs, comma, acting in the name of the deity, as well as the defendant, are Shevites of the said property. For sub next para, the premise of the suit was on the strength of a purported solenama entered into between the parties, whereby they agreed to specific portions of the property being allocated to them respectively. For sub next para, however, comma, it is well settled that the properties of a deity cannot be demarcated or partitioned at the behest of the Shevites, comma, since the Shevites are not the owners of the property, but merely act as the limbs of the deity. For sub next para, hence, comma, any solenama, comma, even if entered into by the Shevites to such extent, comma, is void in the eye of law. For sub next para, thus, comma, the suit filed suit filed was not maintainable in law and in its present form. For sub next para, even otherwise, comma, as rightly observed by the courts below, comma, one of the Shevites cannot sue the other Shevite. Some of the Shevites cannot sue another Shevite by seeking a declaration that the other Shevite is a trespasser, comma, since all Shevites of a deity, comma, in respect of the Devottar property, comma, stand on equal footing, and one does not have better title over the other. Full stop. Hence, comma, we do not find any illegality in the concurrent findings of the courts below. Full stop. Moreover, comma, there is no substantial question of law involved in the appeal. Accordingly, SAT 254 of 2022 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. এগুলো ফেলে দিন। Next.
Wait for it.
Number 39.
My lord, I am for the appellant, my lord.
Appear for the respondent number 1.
My lord, pursuant to my lord's direction, my lord, can 3 of 125 has been filed, my lord. My lord, the respondent number 4.
We directed you to file.
Yes, my lord. That was because on the prayer of my land is friend, my substitution application.
Directed or gave liberty?
My liberty, my lord. That was because
application for addition of who are they?
My lord, they pro forma defendant number 4, my lord. Here respondent number 4, who died, my lord, before passing the decree and judgment, my lord.
Oh, acha, acha, acha.
And for that reason, my lord, on last occasion, my learned friend pointed out.
You are appearing for the heir.
I am appearing for the plaintiff.
Original plaintiff. Respondent number 1, my lord.
What about this application?
But I do not object to this.
My land.
The heirs were substituted in the trial court.
No, my lord. From the order, my lord, the date, my lord, it appears, my lord, he died before the decree and judgment was passed, my lord.
That is probably
your suit.
My suit, but disputed because they are saying 2021 and my instruction is some date in February 2023. But I have not got hold of the death certificate, neither have they.
My lord, we have not annexed, my lord. That is
because I am a plaintiff.
If that be so, my lord, then it has to be sent
same
back
boat with the defendant
for correction of decree, my lord. My lord, let me take instruction
on that. Decree cannot be permitted to be corrected now. They were not substituted there. There is a question of correction of the decree.
Yes, my lord.
We may allow your appeal holding that it's a nullity, or otherwise we can decide the appeal on merits. But for the timing, we are allowing this application, directing them to be implemented. And since you are appearing for the plaintiff's respondent, the others, they didn't have any opportunity to appear in the trial court. So
they had
pro forma defendants, my lord.
Not the rest, the persons whom now are being.
Yes, my lord. They has to be
served.
They has to be served.
Did we dispense with notice on the others?
Their appeal.
Well, it is my.
Did we dispense with notice?
No, my lord, I have
that
not
stage has not come.
No, that is not there. They are the rest of the
what is the nature of the decree?
My lord, that is
preliminary decree in a partition.
Can't you settle between yourselves instead of doing all these?
My lord, the specific case of ours is, my lord, that the plaintiff does not have any right over the property. That is the stand, my lord. It is not between the co-sharers and all.
Didn't provide a title deed. Didn't furnish a title deed.
All have been executed.
That I have to.
I have the decree with me, judgment, everything. My lord, the difference is, my lord, if you permits me to say, my lord, a partition deed was executed between two parties. That is in 83. Yes, 28 in 1963. Thereafter, I claim to be the legal heirs. I have assumed title from one of them, and they say that this deed was not acted upon. Hence, the original heirs should get the property because this partition deed was never acted upon. That is their case. Their defense.
It was a registered partition.
Registered partition deed. Registered partition deed admittedly and exhibited.
That was not acted upon, my lord.
That is their defense.
That was not
a family arrangement. Not acted upon can be understood. But it's a registered deed. I mean, there was a question. It's a transfer
with the decree and judgment which is impugned before your lordship, my lord. For that reason, I am not in a position to, my lord, to assist your lordship with regard to that aspect, my lord. One thing, my lord, what I can place before your lordship, my lord, kindly allow this application, my lord, for the time being, and also, my lord, the injunction, my lord. So far, we are asserting that the respondent number 1 doesn't have any right over the property, my lord. For that reason, if injunction status quo to be maintained, my lord.
What injunction?
Injunction, my lord, from restraining the.
From doing what?
Transferring, alienating.
No, that is not the case. Before the trial court, well, commissioner has been appointed, and the commissioner, when they went to inspect, they resisted. And there
that is a different aspect. Now we
are saying we are in possession, not to disturb our possession, as well as, my lord, do not alienate.
That I am in possession, part of the decree also.
Well, that is under challenge, my lord.
That is under challenge, but you cannot claim that I am trying
in
to
that
dispossess.
My lord, I am very innocuously praying, my lord, status quo to be maintained by the parties.
No. There is a worst possible order.
Well, that is.
The appeal may be disposed of. Date may be fixed.
If
to be disposed
my
of.
learned friend's client
You
is in
don't have any
possession, my lord,
case.
in that event, my lord, he should not be
We'll
prejudiced.
dismiss the appeal outright. That will solve all issues.
Well,
There is nothing in the appeal.
my lord, this is first appeal.
I can hand over.
First step, even first step is we
First
have
appeal can
started
be,
dismissing it
my lord,
because
but
of the legacy we are carrying due to this
My lord,
lenient approach and lethargy on our part.
my lord.
Why shouldn't you dismiss the first step 11?
Well, let me fix the matter on
An
other day, my
interesting
lord.
fact,
Let me
not
place
only
my.
that, they had filed prior 2 suits prior. Those were dismissed for default, 2 separate genealogical.
That was restored,
invited.
my lord. From the record I find, that was
That is not
restored.
my point.
One injunction, one status quo order was passed in that.
You have filed an application for recording death of appellant number 1. And that application was disposed of on the last occasion.
Yes, my lord.
By giving you liberty to file this.
Yes, my lord. That was Can 2 of 2023.
Can 2.
Yes,
yes. And Can 1 is for this injunction.
Yes, Can 3 for.
One
Yes,
is
one for
injunction.
Selling,
injunction.
transferring, alienating will grant.
Yes.
Don't transfer, alienate the property. Only that.
My lord.
My lord.
Regarding possession will not say anything. Since it's only against you, then we are disposing of that application.
That's limited.
We'll direct both parties to restrain both parties from selling, transferring, alienating, creating third party. The appeal arises out of a partition of a preliminary degree passed in a partition suit. For next para, Can 3 of 2025 is an application for addition of the heirs of one of the parties, comma, who died prior to filing of the appeal. There is a dispute as to whether such death occurred during pendency of the suit in the trial court or thereafter. However, comma, even without entering into such issue, comma, since the proposed added parties are admittedly the heirs of one of the deceased original parties, comma, they are necessary parties in our view in the appeal. In any event, comma, since in an appeal arising out of a suit for partition, comma, the fetter as to time bar does not strictly apply since the cause of action arises d die in diem, comma, we do not find any impediment in adding the omitted persons as a party. Accordingly, Can 3 of 2025 is allowed, thereby directing the proposed added respondents, comma, the particulars of whom have been given in paragraph number 2 of the application as party respondents to the present appeal. Next para. Leave is granted to the learned advocate on record for the appellants to incorporate the necessary amendments to the memorandum of the appeal accordingly by tomorrow. Next para. Can 1 of 2025 3 is an application for injunction. Upon hearing learned counsel for the parties, comma, we find that questions of both facts and law are involved in the appeal, and as such, comma, a prima facie case has been made out for hearing the appeal on merits. Since there is nothing before us to indicate clearly as to whether the appellants are in possession of any specific portion of the property, comma, we do not find any scope of granting any injunction with regard to possession. However, comma, in order to maintain the property in statu quo during pendency of the appeal, comma, we direct both parties to restrain both parties by an order of injunction from selling, transferring, alienating, and or creating any third-party interest in respect of the suit property till disposal of the appeal. Can 1 of 2023 is accordingly disposed of without any order as to costs. Next para. In view of the pro forma respondent numbers 2 to 4 having not contested in the trial court, comma, service of notice of the appeal on the said respondents is dispensed with. Service of notice on the plaintiff stroke respondent number 1 is also dispensed with in view of the appearance of the said respondent through his learned advocate. Next para. However, comma, insofar as the added parties are concerned, comma, the appellants shall put in due requisites and postal costs for service of notice of the appeal on the said added respondents, comma, within a week from date. The trial court records shall be brought by special messenger at the cost of the appellants, comma, also to be deposited within a week. The trial court shall maintain skeletal records for the purpose of proceeding with the final degree proceedings. However, comma, no final degree shall be drawn up without prior leave of this court during pendency of the appeal. Liberty to the parties to the appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Great.
Number 40.
Yes, Mr. Mukherjee.
Is then appeal.
Appearing for the first time, this application.
First time.
For direct in service of copies.
Yes, the only thing, a supplementary affidavit we have made prepared.
File that I will direct you to support. Leave is granted to the learned advocate. Leave is granted to the appellant to file a supplementary affidavit, which is filed in court today and kept on record. First of the appellant shall serve copies of the
Section 5
copies of Can 2 of 2023, along with the connected supplementary affidavit, as well as Can 1 of 2023.
Well, that is also one name would be expunged of one of the respondent, my mother, who died.
On the respondents, indicating that the applications shall be listed for hearing in the monthly list of January 2025. Push up an affidavit of service in that regard shall be filed on the returnable date. Push up, yes, whose name will be deleted?
Can number 3. That is Mother Radharani Kundu, the respondent number 1.
She is also a party in Can.
In the suit, she was a party.
No, she's impleaded in
yes,
the cans as well as the appeal.
Yes.
So her heirs are already on
record. Already expunged.
Next para, since learned counsel for the appellant submits that respondent number 1, Srimati Radharani Kundu, has expired, leaving behind her heirs and legal representatives who are already on record, we direct the deletion of the name of the respondent number 1, Srimati Radharani Kundu, leave is granted to the learned advocate on record for the appellant to carry out such necessary correction consequentially in the cause titles of both the applications as well as the memorandum of appeal by tomorrow. Do it by today.
Well, returnable in the next
January month it is.
You
will serve everything, lock, stock, direct. Not the memo, we have not directed that, but the rest.
Without service qualities.
Yes, next.
This matter I am appealing for the.
Yes, Mr. Rai. This is connected with the next few matters.
It is, yes. It is
41 to
50.
Yes.
You are also there.
Yes, that was the order was passed by your lordship's case subject
the order. It is a formal memorandum of appeal to be filed by me within a stipulated period. That was the earlier order. And here is also, it has been converted. Each petition has been converted to first appeal.
So you have filed that memo?
No. Your lordship's order is required. It is in earlier, and there is 31 cases. One case is
order regarding what? Conversion?
No, that is formal filing memo of.
This is in a different matter.
Different matter. Common judgment. All.
এই সবকটা একসঙ্গে দেখিয়ে দাও, হ্যাঁ? All the matters are taken up for hearing together since those arise from connected matters. Full stop, next para.
They have not deposited the amount as your lordship directed.
No. That is in case of that matter, we have already deposited.
That is another matter.
It is another matter. Eternal.
Oh.
Here, no conversion has been directed, so it's not enough. The next para, we find
a copy page.
Learned counsel for the appellant hands over a copy of an order dated March 24, 2025, passed in connection with a similar matter where it was observed that we had directed filing of a formal memorandum of appeal since a writ petition was converted to appeal in the said case. In this case also there has been a conversion order.
No, it is not.
What is the why is writ not maintained? The challenge is against what?
The same judgment, same degree, because there is 31 cases where.
No decree. Then why did you prefer a writ petition in the first place?
Because we are behind our back, the order degree was passed. That's why we challenged.
Decree in what suit?
that under reference case, LA reference case, which we have challenged. Then the writ petition was converted to appeal.
In these today's cases, it has not been converted.
Yes, all are converted. All these writ petition.
These are appearing as first appeals.
First time, yes.
We find that in the present appeals as well, there was an order directing the writ petitions initially filed against the impugned judgments to be converted to regular first appeals. Full stop. Since such conversion has already been done, we direct the appellant in each of the matters to prefer to file a formal memorandum of appeal to set the records straight. Full stop. Such memoranda of appeal in each of the matters shall be filed within
1 week after vacation.
Within January 9, 2026. Full stop. The appellant in each of the cases shall also deposit. There is a statutory deposit required.
No.
If you move a stay, then
we should be served a copy so that we can file cross appeal.
Very well. Copies of the state memoranda of appeal shall be served on the learned advocate appearing for the respondents in each of the cases. We are not making any returnable date. If you file applications, we'll
only without certified, with a certified copy, because in the state has also filed the appeal with certified copy. Your lordships kindly see the order paragraph 8 of the earlier order.
It is further clarified that the memoranda as directed to be filed above, shall be filed with photocopy of the impugned judgment and award, which shall be treated to be a proper filing of the memorandum of appeal within the extant law for the present purpose.
Thank you.
Milord, in this matter, Milord, Mr. Roy is appearing.
Please give his name. Yes, Mr. Paja is yes.
Lordship.
Right.
I'm very sorry.
Exit number 51.
I'm grateful to you.
I beg to appear for the appellant with my application, my lord. On the earlier occasion, the earlier CAN application for stay application was, my lord, disposed of with certain direction of occupational charges. What has happened, my lord?
1 lakh.
1 lakh that I have paid, and also till December 2024, I have paid 10,000. But thereafter, due to some financial constraint, that
serve a copy on the other side.
I have served. This is the affidavit of service. Served upon all the respondents.
What are you asking now in this application?
What I am asking, my lord, is that
this is CAN, which CAN?
CAN 2, my lord.
CAN 2.
What I am asking, my lord, is that the petitioner is willing to pay all the area charges in one go, and till that appeal is.
What is the reason for not depositing? The stay order must stand automatically vacated as per the previous.
My lord.
It has already stand.
Right now, there is no stay order. That is the reason, my lord, I have paid for this.
Why financial crunch? You have not explained financial crunch. What do you do? By occupation business, you have not explained why. What only 1 line financial crunch? That is not sufficient. You cannot come up at your will at any point of time and just.
My lord, there was a.
You have to show
I am admitting, my lord, there was a failure on the part of the petitioner. Kindly, my lord, allows me to pay all the occupational charges on one go, and.
Very well. This affidavit of service filed, you have filed it?
Yes.
Affidavit of service filed today be kept on record. Full of despite service, none appears for the respondent. You have served on whom? The advocate or the client?
No, all the respondents.
No, advocate was appearing on the last occasion. Give a notice to the advocates.
My lord, I sir.
Mr. Shaunak Bhattacharya, Anirban Saharay, Shaunak Mondol, Obhirup Haldar. This was the set appearing. Affidavit of service filed today be kept on record. However, since we find from the records that the respondents were represented by learned advocates on the previous occasions, the learned advocate for the appellant shall serve a notice to the said learned advocates for the respondents, indicating that the matter shall be listed next on December 22, 2025 under the same heading.
My lord.
Thank you.
Great.
Next.
Just one prayer. I am praying for liberty to file a supplementary so that I can explain that reason.
আগেরটায় liberty is granted to the learned advocate for the appellants to file a supplementary affidavit with an advance copy to the learned advocate appearing for the respondent.
My lord, great.
In 53. 53.
এখানে বলা হচ্ছে যে এই এখানে বলা আছে যে ডিউলি ফেল করেছে নিশ্চয়ই কন্ট্যাক্টই করতে পারেনি for the parties at the time of call, full stop. In view of the innocuous nature of the application, comma, we take up the same for adjudication. Full stop. We find from the report of the mediator dated September 16, 2025, that attempts at mediation have failed. Full stop. Accordingly, comma, keeping in view the nature of the matrimonial dispute between the parties, comma, Can 2 of 2025 is disposed of, comma, directing the appellant to put in postal costs and requisites for service of notice of the appeal on the respondent, comma, within a week from date. Full stop. The trial court record shall be brought by special messenger. Trial court record চলে এসছে ও আচ্ছা আচ্ছা তাহলে ক্যান টু ইজ দ্য অ্যাপ্লিকেশন ইজ টেকেন আপ ফর হিয়ারিং যেখানে বললাম তারপর থেকে কেটে দাও বলো রেকর্ডস কি এসছে সব ও আচ্ছা সব রেডি তাহলে সার্ভিস সেক্টর is taken up for hearing, push up. The said application is one for expeditious disposal of the appeal. Push up, in view of the urgency involved in a matrimonial proceeding, let the appeal, comma, which is otherwise ready for hearing, comma, be listed under the appropriate heading for hearing in the monthly list of January 2026. Next. Can 2 of such and such is disposed of accordingly?
My lord, 53, I am appellant for 57. My application for restoration, my lord. My application dismissed.
Filed within time?
Yes, no, my 232 days delay.
You have filed a section 5 also?
Yes, my lord.
What is the reason for you have served on the other side, or this is the first time it is appearing?
My lord.
This is appearing for the first time.
First time, my lord.
Was it an ex parte? Oh, section 5 you have to serve.
Section 5.
The appellant shall serve copies of can.
I have served the.
You have?
Yes.
There was a direction by us. Without direction, you cannot serve. If you serve, if they don't appear, then you have to serve again. Affidavit of service filed to be kept on record. Full stop. However, comma, since such service was sought to be effected without any direction of the court, comma, we direct the appellant to serve copies of Can 1 of 2025. Can 1 of 2025 as well as Can 2 of 2025 afresh on the respondent, indicating that the application shall be listed in the monthly list of January 2026. Full stop, the appellant shall file a fresh affidavit of service on the returnable date. Next.
I appear for the appellant. I have filed two applications. One is the one is for section 5 condonation of delay. I have served the copy of the application.
You're appealing for the other side?
Yes, sir. The 68 days delay.
What is the reason?
Paragraph number 5.
Yes, what do you say to the section 5?
Sir, it is, my lordship, it is up to your.
Very well. Heard learned counsel for the parties, full stop, in view of sufficient cause for the delay in preferring the appeal, comma, being the ailment suffered by the appellant during the relevant period, comma, having been made out, we are of the opinion that the delay in preferring the appeal ought to be condoned. Stop. Accordingly, can 1 of 2024 is allowed on contest, thereby condoning the delay in preferring FAT 96 of 2024. Full stop, the appeal be deemed to stand registered and admitted. What is can 2 and what is the appeal about?
2 is not the matter arises out of a suit for specific performance of contract.
Dismissed.
Not dismissed.
No scope of stay. Will direct the records to come and all.
Let it become, let them not to transfer, assign the property.
File an injunction application.
File can 2.
Can 2 is an application for stay of operation you have mentioned. What is the prayer?
Comes to the prayer portion.
Yes. Oh, prayer is injunction. Very good.
Earlier in the court below has also granted an injunction.
Very well. So change of nature, character and transfer. You are granting that injunction because of that.
Your lordship, we haven't received can 2.
You haven't received?
Yeah. And neither we have received the appeal. FA 96.
Appeal you are not entitled, you will get with the paperwork, but application.
Let them not transfer, assign the property.
Yes, but you have not served a copy. Should you grant that injunction and dispose of the injunction application?
I don't have such specific instruction from my...
Since no copy of can 2 of 2025 has been served on the respondent, but the respondent is represented through counsel today, comma, a copy of the application be served on the said learned counsel. Push up. We are apprised that that such copy is handed over here and now to the learned advocate for the respondent. Push up. Accordingly, let the application be listed on December 22, 2025.
Lordship.
Under the same heading.
Your lordship, we have preferred an appeal. That is FA 90.
Let both be tagged together.
You have an application in connection with that appeal?
FA 90.
Separate appeal.
Separate appeal. It is well
filed an application in connection with your appeal?
Yes.
What is the application number?
FA 90. FA 90.
No, what? You don't know or haven't filed?
I actually don't know about this.
Then that cannot appear along with the... How can it appear? An appeal cannot appear with an application. No, when you dispose of the application, will direct both to be heard together.
I am filing the affidavit of service.
Affidavit of service filed to be kept under. Affidavit of service aage kore debe. Out of 22 tarikh, let it come on 22nd. When we take up the matter, we'll pass all details.
Yes. My lord, 53 dismissed for default, my lord. 53 dismissed for default.
Yes, serve again and come back.
56.
55, my lord, and 56, I am for the appellant petitioner, my lord.
Yes, what is that?
My lord, I'm a bit under the weather, my lord. I'm, my lord, apologizing, my lord, for online.
When can you get over the weather?
Physically, my lord, a bit under the weather, my lord.
When should you keep it? Tell us.
My lord, I can, my lord, move, my lord. There's a section 5 application, my lord, and there are other applications, my lord. I'm ready with my application.
You're appearing for the other side. Who is appearing? You're with him.
Lordship.
Appearing for the first time, or you have soft copies?
No, I have soft copy, my lord.
Affidavit of service? What is the endorsement there?
My lord, we have refused. We have tried to serve them.
It's the endorsement.
My lord, the endorsement is, my lord, so far, my lord, my knowledge goes, my lord, some of them have refused, my lord. There's a refusal.
Refused. Affidavit of service filed. What is the... let us record this first. Affidavit of service filed to be kept on record. It transpires that the envelopes sought to be served on the respondents have returned on some of the respondents have returned with the endorsement refused, comma, which tantamounts to good service. What about the others? We find only 3 envelopes. Others have been served.
My lord, there is not a case, my lord, that Copy has not reached, my lord. So far, my lord, my instruction goes.
No copy has been served as yet. Alipur HO. No, sorry. New Alipur SO. That is the last endorsement. They have not been
My
served.
lord, let me comes back, my lord. Let me comes back, my lord. Kindly, my lord, keeps it, my lord. After a week, my lord, let me comes back.
Well, however, comma, it transpires that the other respondents have not yet been served. Push up. We'll keep it after the vacation then. In 1 week, what will happen?
My lord, my lord.
Accordingly, let the applications be listed in the monthly list of January 2026 under the same heading. The affidavits of service filed today be kept on record. প্রথমে হবে affidavits করে দিও হ্যাঁ ছেড়ে যাবে
Item number 57.
In this matter, my lord, appeal filed by the husband against the my lord, order passed by the lord, dismissal of the divorce. Thereafter, my lord, I filed on an application for maintenance. Your lordship directed to file affidavit of asset, both the parties, my lord. I filed, but they did not file, my lord. Thereafter, my lord, my Honorable Justice Somensen, lord, passed an order, my lord, March 2024, they did not, my lord, given any money. In spite of the order passed by the lower court 15,000, that lordship directed to ad hoc payment 50,000. Thereafter, application will be adjudicated. Thereafter, my lord, final application that per month 5,000 or like that, my lord, installment. That's application, my lord, file.
That is pending.
That is a pending today. That matter that will be heard, but their submission that we are not in a position to pay at this 50,000 at a glance. Kindly make an installment. Order dated, my lord, August. Till today, my lord, did not file.
Yes.
In the meantime, mediation, my lord, goes. Lord, I am, Lord, in the mediation, my lord, I admitted that I is willing to stay, but he refused to stay, my lord, the husband, and not paying any money.
Yes.
Your lordship, in the last date, we filed for a modification
Take
application.
the microphone closer to you. Move that modification application.
And we
Why should you modify the order?
no, sir. Your lordship, there was some necessary change needs to be done, so we filed the modification application, and we filed it next earlier, and we served the affidavit of service to the.
Did you last pay alimony? When did you last pay alimony?
Your lordship, I don't have any.
When did they last?
Before 1 year, March 2024.
March 2024. 24. So more than 1 year, almost 1.5 years, more than that.
That time, Lord,
What was the amount granted during the suit? 15,000.
Thereafter, my lord,
We are rejecting this application for modification right now. And what about the alimony application? They have not yet filed their opposition.
In this
In the main
in the main suit, my lord, in respect of the
No, no, here,
suit,
here,
in
here,
respect of the divorce suit, my lord, file divorce dismissed. That's why.
No, not that, not that.
In that case, my lord, your lordship directed also file an objection, not file.
Can 3 is for modification. We are rejecting that.
Yes, my lord.
What is can 2?
Can 2 for alimony, my lord.
Can 2 is for your application for alimony, right?
Yes, my lord. In respect of can 2, your lordship directed to file an affidavit of asset along with the.
You have filed your affidavit of asset.
That's it. I served this copy and
they have not filed in opposition.
No, opposition, affidavit of asset, nothing. Neither affidavit of asset nor objection. Your lordship directed to file affidavit of asset along with the objection.
No, then we'll dispose of the alimony application also. Yes, we are disposing of both. We are rejecting your modification application. We are directing alimony to be paid at the rate at least as last paid, 15,000.
Your lordship, affidavit in opposition on behalf of the appellant is served.
Which matter?
In this matter,
Which can?
it's
No can number.
we are filing the opposition today, sir.
Which can?
We are filing today the opposition.
Can not mentioning in this application.
Opposition to which application? What is the can number of the application to which you are filing the can? To which you are filing the opposition? একে পাঠিয়ে দিয়েছে বাচ্চাটাকে নিজে বসে Who is appearing along with you? Somebody is appearing with you?
Yes, sir. My senior is suffering for high fever. That's why
Who is he?
Moon theory.
The advocate on record is Shohini Odhikari, Miss Shohini Odhikari.
She will be moving the matter.
Yes, sir.
So why didn't you ask for time?
Sir started.
We'll,
I am
we'll,
not.
we'll adjourn it till.
My lord, I am not receiving any alimony. My lord.
We'll adjourn it till Monday only.
My lord.
An adjournment is sought on behalf of the appellant, Fushab. Learned counsel for the respondent wife submits that since April 2024, not a single paisa is being paid by the appellant husband in by way of alimony. Fushab, next para, learned counsel for the respondent stroke wife draws the attention of the court to a previous order passed by this court dated passed by a coordinate bench dated August 6, 2025, whereby the matter was sent to mediation and a sum of rupees 50,000 was directed to be paid to the respondent wife by the appellant husband. Full stop, next para. However, it is submitted that the said amount has not been paid, semicolon, instead, the present application bearing can 3 of 2025 has been filed seeking modification of the said order to the extent that the appellant husband seeks to pay alimony such amount by way of installments, monthly installments of rupees 5,000 each. Full stop. Next para. Learned counsel also points out, learned counsel for the respondent also submits that in the teeth of the previous direction on the appellant husband to file affidavit in opposition to the application for alimony filed by the respondent wife, no such affidavit has yet been filed by the appellant husband, despite the respondent wife having filed her affidavit of asset in connection with her alimony application. For the next para, although learned counsel for the appellant seeks to file an affidavit in opposition today in court, it transpires that the affidavit does not disclose as to which application, in respect of which application such affidavit is sought to be filed. Full stop. Be that as it may, since an adjournment is sought by the appellant, as a last chance to the appellant to move his application as well as to contest the alimony application of the wife, the matter is adjourned till December 22, 2025. Full stop. It is made clear that in the event the appellant husband fails to contest the matter on the next occasion and or is unrepresented or seeks adjournment, the matter may be taken up in the absence of the appellant. Affidavit file করেছে? Affidavit of service file to be kept on. If you can, please communicate a copy of this order to the advocate on record. She may be in an embarrassing position otherwise. You just communicate to the advocate on record in writing. A server copy of this order. Yes. Yes, Mr. Dattu, what is the matter?
I appear for the appellant, my lord. I am told that there may be a defect. My lord,
in the list.
it is my mistake, my lord. I could not.
Let us
the
see.
records.
লিস্টে আছে না দাদা লেখা
হ্যাঁ
ডিলে আছে তো
Delay 267 days.
Yes, আমি তো বললাম 10 মাসের ডিলে
I am told that there is CAN 1, which is an application for condonation of delay.
Is this appearing for the first time?
Yes, first time.
Serve copies and come. The appellant shall serve the
There is
appellant.
also CAN 2, which is for
Will
application.
direct both to serve. The appellant shall serve copies of CAN 1 of 2024 as well as CAN 2 of 2024 on the
আরে কোর্টে অর্ডার করছে তুই শিওর
respondent,
আমার ক্লায়েন্ট নাই
indicating that the application shall be listed under the appropriate heading in the monthly list of January 2025. First of the appellant shall file an affidavit of service to that effect on the returnable date.
May I have a look at the report? CAN 1 টা দেখ
Yes.
I am for the appellant.
Right.
The respondent has taken out one application. In respect of that application, my lord has directed to file affidavit in opposition, which we have filed. And my lord, towards our affidavit in opposition, perhaps they are filing the affidavit in reply.
Before that, I make one submission. Mr. Gautam Banerjee is in this matter. His wife is got admitted in a nursing home. So, my lord, it's a affidavit in reply he has given to file this, and lordship kindly fix a date as your lordship's convenient. But if he fail, I will come.
Fair enough. Affidavits in opposition and reply filed today be kept on record. Full stop. On the prayer of learned counsel for the respondent, comma, the matter is urgent till when?
No, not prayer, my lord. I have already filed affidavit in reply. That's why. Otherwise,
then we'll hear the matter.
Claimant is there.
Then we'll hear the matter. If you're not asking.
No, lordship, let them fixed.
Then you are asking for time.
Yes, yes, I am asking.
When should you keep it?
Coming week, my lord.
On the prayer of the appeal, যেখানে ছাড়লাম সেখান থেকে, let the matter
I
stand
hope, my lord,
adjourned.
he will recover.
We also hope.
Twist them,
Sincerely, yes.
Twist.
Let the matter stand adjourned till December 22, 2025. Next.
Grateful.
Thank you.
Biplab.
Thank
I appear for the appeal.
you. Yes.
My lord, there is a delay of 239 days. Fix my application.
Somebody appeared for the appeal?
Yes, yes.
They have filed an affidavit in opposition.
Lordship.
You are not filing any reply to that.
No. Kindly grant us some time to file. Because only the other day we got it.
Very well. On the prayer of learned counsel for the appellant, comma, the time for filing affidavit in reply is extended for a week from date. Full stop. Let the matter be listed. Let the applications be listed in the monthly list of January 2026.
Lordship.
Number 61.
I'm appealing for the respondents, madam. 1 and 2. On the last occasion, your lordship directed us to assist the court with filing the copies of plaint and miscellaneous case that they have filed, the appellants.
Very well. As per previous direction of the court, comma, learned counsel for the respondents files copies of the plaint
And a miscellaneous case.
and miscellaneous case filed in the trial court. However, comma, at the time of call, none appears to move the applications. Full stop. We find from the records that on November 25, 2025, as well, comma, an adjournment had been sought on behalf of the appellant. So, as a last chance to the appellant to appear and move the applications, comma, the matter is adjourned for the day. So, it is made clear that in the event the appellant fails to move the matter on the next occasion or seeks for an adjournment, comma, the matter may be disposed of ex parte in the absence of the appellant.
Let may it be taken after vacation,
Adjourned for the day বলেছি adjourned till after the upcoming Christmas vacation.
I'm grateful.
মার্কেটে যা আছে তাই
I'm grateful.
মান্থলি লিস্টে দিয়ে দেবেন। Thank you.
I'm grateful.
Number 62.
For the respondent.
You are not traceable, that's why they wanted to say it was mentioned and we recorded also. You are not traceable, that's why it was served directly on the your client has received.
No, my lord. As a matter of fact, the
although
judgment and decree under challenge has been executed, my lord. Suit for
although it was recorded in the order dated October 28, 2025, comma, as per submission of the appellants, comma, that the respondent's advocate was not traceable, comma, he is traceable now and appears before us. Full stop. It is submitted by learned counsel for the respondents that the decree impugned in the appeal has already been executed. Full stop. Next para. Be that as it may, comma, since none appears for the appellants themselves, comma, let the matter stand adjourned for the day. Full stop. It is made clear that in the event, the appellants remain absent on the next occasion when the matter is called on for hearing, comma, ex parte orders may be passed in their absence. Please bring whatever is there, degree satisfaction, whatever report, beliefs report, or it is already with you.
Yes.
We have given them a last chance. On the next occasion, also bring those. We'll keep those on record and dispose of the. At least the application. Appeal, appeal cannot become infectious because 144 is.
My lord, before my lord rises, yesterday I had mentioned.
Every day, whenever we rise, you say before we rise, we rise.
No, my lord, it's that matter which I had mentioned and taken leave on Thursday, my lord. Tomorrow is a hearing day, my lord. Has hearing matters up.
What is the item
It's
number?
an item 183. It's an order 41, rule 11, my lord. I have an urgent prayer, my lord, in that. The order passed by City Civil Court restraining me from creating third-party interest in respect of property situated on AM bypass. Ex-officio without jurisdiction. On the plaint itself, it will go.
You are for the other side.
Yes, my lord. I've served notice, my lord. Kindly, my lord, takes it up before the hearing matters yesterday, tomorrow, my lord.
কালকে specially fixed bill heading করে
Deeply applied.
hearing
Item 183 of today. Deeply
Lordship, kindly one.
আমার কাছে কিউরি আছে ওকে শুনে নাও নোট ফোট গুলো নিয়ে নাও
My lord, I had prepared a note with all the relevant notifications.
Thank
if
you
I
very
may be
much.
permitted to pass that.
এই নোটটা আজকে দিলেন না
তিনটে আলাদা কপি আছে. I have annexed all the circulars also with this note.
আর্গুমেন্ট প্লিজ
Enough.
Yes, this is
Yes. হ্যাঁ হ্যাঁ তিনটে আলাদা আছে
You hear, Mr. Shivabalan?
আরেকটা দিয়েছেন।
আরেকটা আছে
এখান থেকে
এটা নোট করে দিয়ে, হ্যাঁ নোট করে। কম্পাইলেশন একটা আলাদা দিয়েছেন।
Mr. Shivabalan.
শিববালান কোথায়?
আর একটু জোরে চিৎকার করলে আন্দামানে শুনতে পেয়ে যাবে।
একটু জোরে বল।
Lordship, I am for Port Blair, Lordship, in reference matter.
Oh, you're
You have submitted that you are supporting the notifications.
Lordship.
So nothing else you want to add? Anything else?
Lordship, I already made my argument last time.
Appellant.
Subtract also if you want. You can subtract anything if you want. Since you don't want to add, you can subtract.
FA3 তো ওটা অন্যটা তো FA3.
Lordship, I already made last occasion.
Mr. Shivabalan appeared for the appellant in FA3. Where is he?
100% শুনতে পেয়ে যাবে।
And Mr. Mishra.
Mishra, on last occasion, Mishra on my
This
behalf.
occasion, where are they? Where are they now? Beside you in some other room?
No, Lordship, Shivabalan, I just personally called him also.
Call him.
Please,
We've only adjourned it till today for him.
We are waiting for 2 minutes. Let him come.
Lordship, I personally talked with him that he is coming.
You personally take responsibility so that he comes.
Lordship.
এতক্ষণে এই যোগগুলো বুঝবে। সাবট্রাকশন তো
EOMES
কোথায়?
বাবলাম তো নামের মধ্যেই লুকিয়ে আছে ওর।
শিবাও আছে, বালানো আছে, তো সময় তো লাগবে।
So Chakraborty and Mr. Chatterjee can take your seats. No use keeping standing.
চ্যাটার্জি আসে কেন? সিস্টারও তো কিছু একটা আর্গুমেন্ট এক লাইন আর্গুমেন্ট করেনি।
এত আর্গুমেন্ট করেছি।
এই তো আমাদের ঠিক দেওয়া উচিত আর ও তো
Submission fee.
My lord, my senior VD Shivabalan is appearing in another court, my lord. I'm short passover praying.
This is the only matter. We are sitting only for your matter and we cannot sit again. Sorry. Let him come immediately. You do the matter in the other court and ask him.
Madam, you start.
Short passover.
Lord Saibra, they are lenient.
My lord, I am appearing, my lord, for the appellant, my lord.
Yes, yes, Mr. Sevan. We are eagerly waiting for you. Now, please start.
My lord, on instruction, I am submitting that my client
Not interested.
he is telling that he
He
is
won't pay.
on merit. This
You are hearing a reference, Mr. Shivavan. You should understand the significance of a reference.
Yes, my lord.
We are not hearing on merits or anything of that sort. On reference, on this question which has been referred, what is your answer? What is your argument on the law point?
On the law point of the judgment which has been referred by the appellant, my lord, earlier in the order sheet, that of this honorable court, my lord, that as per that judgment, the matter has to be jurisdiction is lying before the honorable High Court, my lord.
We are the Honorable High Court.
Yes, my lord. The above 1,50,000, the valuation of the suit, as per the judgment of the honorable High Court, it lies before the honorable High Court, not before the district judge, my lord.
As per the Honorable High Court, also it lies before the District Court. Both are High Courts.
Yes, my lord.
So, what is your argument on that point? What should be? Where should it lie? And why?
My lord, since we are Footwear Andaman and Nicobar Island is also comes under the jurisdiction of Chief Justice of Calcutta, West Bengal, my lord. As it is comes under the Chief Justice of this honorable court. So that West Bengal Act is also applicable to the island also, my lord.
Why?
Under the same Chief Justice, my lord.
Chief Justice
of West Bengal. We
Under
are
the same Chief
circuit
Justice?
bench also comes under the West Bengal Chief Justice jurisdiction, my lord.
It note under the same Chief Justice. Oh, that is his argument. You have to record it. না কেন রেকর্ড করবো না করবোই রেকর্ড না করলে আমি করবো সেটা ডিফার কর সেম চিফ জাস্টিস You can turn it down, but it's a valid argument. Actually, Chief Justice is under it. West Bengal court, the Chief Justice is under it. Andaman court, the Chief Justice is under it. Why shouldn't there be parity?
The Andaman Nicobar's Island Civil Codes regulations of 1940 established those codes, right?
My
So
lord.
will those supersede and the Bengal Agra Assam Civil Codes Act? How will that is limited to certain areas to be administered by the Lieutenant Governor of Bengal, Lieutenant Governor of Northwestern Provinces, Chief Commissioner of Assam,
My lord.
except those territories. We don't have to go to that.
Yes, ma'am.
So the jurisdiction of the civil courts in West Bengal, they are within under the said act. Now the Andaman Nicobar Islands, the courts, they were established as per the regulations of 1940, the civil courts, right?
My lord.
So why will not the 40 regulation override the provision? Actually, there is no conflict because the Bengal Agra Assam Civil Codes Act has restricted its operation to particular provinces, which includes Bengal, does not include Andaman.
My lord.
So then, in this situation, what would your argument be? How would you say that the hierarchy of courts, as in Bengal, will be also prevalent in Andaman, and the pecuniary jurisdiction of an appeal, as it is in the High Court, is more than 1,50,000. That should be what is the pecuniary jurisdiction for this district judge cannot have a pecuniary jurisdiction which is at par with the High Court.
My lord,
District Judge of Andaman.
my lord, my submission would be, my lord, I agree, my lord, that district judge is having unlimited jurisdiction. Even then, the Honorable High Court is also having the original jurisdiction since it is comes under the principal bench, my lord. Even the High Court is also having the jurisdiction, my lord.
So concurrent বলছে. Are you saying that the district judge and High Court will have concurrent jurisdiction?
My lord.
Then where will the second appeal lie from the High Court judgment? Then a second appeal will lie if someone files an appeal before the district judge, but it will not lie if someone files it before the High Court, if you say it's concurrent jurisdiction. If a first appeal lies to both courts, then there'll be a classification, an unreasonable classification. If I choose not to have a second appeal, I'll file it before the High Court directly. And if I choose to have a second appeal option, then I file it before the district judge. How is that resolved?
Yes, my lord, that is a
tough, very tough.
Addiction, my lord, because the one act is applicable to the Honorable High Court, the other is applicable to the district judge.
So that is why what is applicable in case of Andaman, that has to be applied to Andaman. Establishment of courts as per the 1940 regulation. Because the Bengal Agra Assam Civil Courts Act or the Bengal Civil Courts Act before that did not have any provision with regard to establishment of courts or with regard to jurisdiction of civil courts in respect of Andaman. Right?
My lord.
We are only giving our judicial presence, as in the judges of the judiciary of West Bengal mans the judicial, the offices there, but that doesn't give us the jurisdiction contrary to the 40 Act, 40 regulation.
It comes from the government of India.
Madras hole hoyto alada hoto. Who knows? We don't know what their hierarchy is.
I am leaving it to the my lordship.
All right, judgment reserved.
My lord, only one request, my lord, if the
hard করে দাও সবাইকে।
Hard সবাই আর the written notes.
No, the learned amicus curiae has submitted a compilation and a short note. Heard learned advocates for the respective parties in both the appeals. Judgment reserved.
My lord, one prayer, my lord,
This
if the
bench appreciates the contribution of the learned amicus. Yes.
My lord, one prayer, my lord, last prayer.
Yes.
The Honorable Court holds that the Honorable Court does not have the pecuniary jurisdiction, district judge is having, Then, my lord, my appeal may be transferred to the district judge.
No, we are just hearing the reference. We have to revert it back to the wherever it is.
Obliged, my lord.
ওর appeal তো হয়ে গেছে dispute, নাকি?
No, pending, my lord.
আমাদের কোশ্চেনটা আনসার
না, রাজস্বী কি করেছে?
না ওটা the appeal which that is still being heard.
And yes, my lord.
From
It is,
which the reference came.
yes, my lord. It is pending.
That matter is over.
FAT4 is over.
FA3 is pending, my lord.
In the Supreme Court, who has gone? Your other side has gone to Supreme Court.
Yes,
where he is up.
Yes, that's in
That will-
Supreme Court now. So after we return our finding, we answer the reference, sorry. The Supreme Court will take up the matter and that prayer you make before the Supreme Court, whichever way the appeal goes. ঠিক আছে, হয়ে গেছে।
my prayer may be recorded, my lord, so that if it in so honorable before the honorable Supreme Court, I can mention it.
আর রাজস্বীর কাছে যেটা বলেছিল সেটাই লিখে দিল ওরা argument হয়, তাতে আর কি?
ওটাই ঠিক হবে।
Prayer record করবো বলছে যে
Send the appeal to the district judge. That how can we do? Now it is pending before the Supreme Court. We can't do that.
My lord may deny it and
We can't say that. Then it will be like you are conceding that if you are not satisfied with my argument, then I'm willing to go to the district judge. That can't be done.
My lords are only answering.
We will only answer that question in a short way.
a hypothetical contingent situation. I mean, we cannot record a submission on that.
Because the appeal from this court's order is already in Supreme Court, the SLP.
my lord, FAT4 has been transferred to the district judge.
FAT4 has been finished. It's over. The
Other
argument
one is over.
It has been transferred to the district judge, my lord.
only FAT3.
It is done and disposed of.
Yes, ma'am. No,
আমরা রেফারেন্সে আনসার দেবো ব্যাস।
No.
দেখে নাও।
and for if it is dismissed, then I will be lose a case on merit.
Not dismiss. The question before us is whether Justice Bharadwaj's judgment or observable decision or Justice Bhattacharya's decision is the correct one.
The reference is
We
only
only
on
have to
whether-
answer that.
Yes, only on whether the district court has unlimited jurisdiction or we have jurisdiction over that. So that will be answered only in the reference. We don't have the charter to do anything else.
My lord.
Nothing is being dismissed
Nothing
here.
will be dismissed or allowed.
Your matter is
Answer
pending.
the question and
Supreme Court.
refer it back to the Supreme Court.
My lord, between 1830 and 1867, even Singapore was administered from Calcutta, but as a separate states commission. So, my lord, even this Andaman, the chief commissioner was reporting to the governor general,
Right.
who was in Calcutta till
Yes,
1911.
physically located in Calcutta.
Yes, but the lieutenant governor's is a separate concept. That is a
Exactly.
separate administrative.
Yes, yes.
Longitudinal and a latitudinal, my lord.
That was your argument, yes.
There was, and it is there, still there. But after the act came in, my lord, it completely went.
Starting from Eden to Singapore.
That's where the longitudinal and latitudinal.
I was going to.
It's interesting.
All these were not placed when mine happened.
Nothing was placed before, nothing.
Only went on appellate side.
Appellate side was placed before it.
दोनों